Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within and for the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning, everyone. Welcome to the Appeals Court. I am Justice Rubin. To my right, Justice D'Angelo. To my left, Justice Toone. We will be the panel sitting this morning. We will hear 5 cases, and we will take our traditional mid-morning break after the second or third case. We'll let you know. The rules here are as they always are, and some of you I know have been here before. It is 15 minutes per side. There is no rebuttal. If there is a division of time, which I don't think there is today, you should let us know when you approach the podium so we'll know how many minutes to give each person. I think that's basically it. We've read the briefs with some care. We're very familiar with the facts of the cases. And so my recommendation would be to get right into your arguments, but of course it is your time to use as you wish, and that is only a suggestion. And the first case we will hear this morning is number 24380, Commonwealth versus Eberhart. And we will hear first from Attorney Miles.
Good morning, Your Honors. Mary Miles for the appellant, Anthony Eberhart. Mr. Eberhart requests that his firearm convictions be vacated or that he be granted a new trial and that he be resentenced before a different judge. If it's okay with Your Honors, I'll start with the firearm issue. Here, the Commonwealth failed to present substantive evidence of the defendant's date of birth, very similar to the situation in Smith, which I argue warrants reversal of those convictions. Officer Perez, or Detective Perez, testified that he searched spelling of Anthony Eberhart, and then I believe he searched 3 or 4 different dates of birth, different years and different dates, to come up with the conclusion that the defendant sitting before the jury didn't have a firearm license. But what was missing is any substantive evidence as to why those dates and that name, that spelling was attributed to the person sitting before the jury. This is the logic that the SJC recently used in Smith. The Commonwealth's contention that the fingerprint card introduced into evidence by the crime scene unit sergeant corrects their error is without merit. In that situation, the fingerprint card was admitted to show comparisons that the sergeant used for fingerprints on that card and various. I
don't really understand that argument. I understand that it was only used for that. But things aren't admitted for one reason, and the jury can't look at them for another reason. It's in evidence, and no one contested the birth date and spelling, presumably because they were correct, but all right, that's not really the issue. So it wasn't a contested issue. In criminal cases, isn't evidence of elements introduced all the time about uncontested issues, and then whatever, it's in, and the jury gets instructed on it, it's right there.
But we don't have any testimony that date of birth on that card was the correct date of birth. We don't even have the defendant's signature, right? On that card, it says signature of defendant fingerprinted. There's no signature on that.
That go to the weight of the evidence? And isn't it enough for the jury to see the defendant's name, see spelled presumably the same way, see a date of birth on the fingerprint card, and hear the date of birth that the officer testified to? Isn't that the weight of the evidence? It's up for the jury to decide it?
Well, I think Smith instructs the Commonwealth that it needs to present some as evidence as to why that date of birth searched by that officer is attributable to the defendant present in court.
But in Smith, they didn't hear any date of birth because it was excluded by the trial judge. Here, there was a date of birth presented to the jury. 2 dates of birth, one on the fingerprint card and one that Officer Smith testified to. Can't the jury infer from that those are the 2 dates of birth of the defendant and say, yep, they match up, that's good enough?
Perhaps if the prosecutor had asked during direct examination of Perez, is this the date of birth, looking at the fingerprint card, right? And looked at the date of birth and said, October was the 23rd, 1979, that is the date of birth I used. We know this is the accurate date of birth of the defendant because XYZ, because this is the date of birth he gave at booking, and that's the date of birth. All those links in the chains of evidence, I would argue, were not satisfied by the Commonwealth.
If it were a driver's license, would it be okay?
Well, yeah, it's the driver's license that the defendant or
Without any testimony, just a driver's license happens to be in evidence. No one's fighting about the birth date. But they admit his driver's license because something, it shows his address or something, and so they admit it. But
Well,
no
that-
one says, driver's licenses, this is how they get the birthday, and would they have to do that, or is that some kind of
I don't
common
think
knowledge?
so. I think the common knowledge of the jury, right? They know you go to the DMV, you sign your driver's license, you have to prove a birth certificate, passport, et cetera. There's all these requirements and checks and balances for the correct person getting the driver's license. Here we have a fingerprint card. We don't have a defendant's signature. We have no idea how that date of birth got there. We also have Perez testifying that he searched different dates of birth. Well, then at what point, what is the defendant's correct date of birth? Is that one on the fingerprint card, or is it the 13th? We don't have any
Your argument is you needed some additional evidence to explain what the known standard meant. Just drawing the distinction between Justice Rubin's example of the driver's license, what additional evidence do you think was necessary to sort of establish this, to raise it to a sufficient evidence?
Well, I think a lot, as of right now, after Smith and, prior, before that case was being briefed, I think the Commonwealth is using like board probation records or whatnot, as long as they're certified and everything is blacked out. So you have some sort of official document saying this is what's used by the government. A police officer can testify to that, and that lends its credence to the reliability of the information on that car, right? Here we have absolutely no testimony whatsoever as to the birth date on this fingerprint card. We just have it introduced to show that these are fingerprints compared with some things that were found at the crime scene.
So that's your sufficiency argument. Can you
Correct.
talk about let's assume you don't win on that, but you still have an argument as to
Correct.
the foundation for the statement under the hearsay rule. Do you want to speak to that issue?
Yeah, absolutely. I think it's pretty clear that Perez's knowledge of the record-keeping government practices of the record-keeping practices of the government for the CGIS database was considerably less than that of Dowd's. While I don't think dispositive, Dowd is a CGIS employee. Perez, yes, it's very clear that he can testify as to how to search a database, right? But he has absolutely no information as to how the records are entered, how are they maintained, how are their checks and balances to ensure that this person entering these records is, giving the correct spelling and date of birth, and are there any checks and balances for human error? What are the firearm licensing processes? How does this happen so that we know that this search that Perez did was accurate?
Could someone who's not a CGIS employee provide that information?
Absolutely.
Yeah.
I don't think that, like I said, I don't think that's dispositive. But you have to give the jury some sort of foundation to say that this search that I've done of CGIS is accurate, and I know it's accurate because of these record-keeping practices. I think the two cases, the Border Patrol case and the Forest Service case that were cited in Smith, Parker and Diaz-Lopez, I think, or Diaz, were both, very familiar with how records are entered, how they are stored, how you retrieve that information, the checks and balances, just like Dowd testified to. Unfortunately, Perez was totally lacking in that information. And understandably, Guadardo happened right when this case was that testimony. So it's not like it was under the Smith standard, I would argue, an abuse of discretion. But, the prosecutor was struggling, defense counsel struggling, judges struggling to how to kind of wrap themselves around this new Guadardo landscape that they
Can I
found themselves
ask you
in.
this about knowledge of the database and how it works? The SJC cites an out-of-jurisdiction case in Smith, and the parenthetical, though, has this quotation in it: "The extent of a witness's knowledge regarding particular database policies and procedures is a fair subject for reasonable cross-examination, but goes to the weight accorded to the testimony rather than to its admissibility." So, now admittedly, that's just a parenthetical in, following a citation, although I'd say it's, sort of quoted with favor. That's a list of, it says something like other jurisdictions have done the same thing, and rather than just citing the case, they put that in quotation marks. And then later on, it says, of course, the defendant is free to challenge the extent of the witness's knowledge through cross-examination. So why isn't this an argument more about weight than adequacy? I mean, obviously, if something had no weight, I guess it would be inadequate. But do you see what I mean? Like, what?
Yeah, no, and I understand what you're I understand what your Honor's saying. I think there could be a situation where you have a CJS employee who actually is responsible for a coder who is maintaining that, right? Or you have a CGIS employee who, just knows how to search and goes through general training that they're given and whatnot. I would say that goes to the weight and is fodder for cross-examination. What we're talking about here is a foundational issue. And I don't think, how can you cross-examine someone if they don't have any knowledge of anything? You can't ask so...
I thought he said something like people from the town put the licenses in, or from his particular town or something. Am I?
No, he just said that records are inputted from police reports through the records department. I've never seen that done. I don't know how it's done, and that's all he said.
But he did say records are inputted from the police department. I mean, I have to look at the exact
But what
language,
records, how? I think the SJC was clear in Smith. There needs to be some sort of information to judge the accuracy and the reliability of that search, that the jury can, gauge that opinion and, adjust or look at the credibility of that, search. If he doesn't know anything and he's just familiar with searching them, you have to have something.
Well, it seems to me, I'm going to boil down Smith to one sentence that they have in it, that in order for somebody to testify about the records, the government has to establish that he is familiar with the process of searching the database and adequately establish that he understood the relevant government record-keeping practices.
Exactly, yes.
So and I think you're latching to number 2, if I say it's 1 and 2, that they did not adequately establish that he understood the relevant government record-keeping practices. So my question to you is it the record-keeping practices of CJIS that the witness has to know, or does the government have to establish that the witness knows how the records get to CJIS?
That's a good question.
Because I think here, to follow up Justice Rubin, he might know the record-keeping process of CJIS because he's very familiar with CJIS, did it in the military, he knows how to search it, etc. But his testimony was he didn't really know what the local police departments did to notify CJIS.
So I would disagree with that summarization of his testimony. I think he was very familiar with the searching, but he was clear he didn't know how they were maintained, he didn't know how they were entered. So, I mean, he said on direct testimony, I don't have that quote, but he said he does not know how they're maintained. And so I would argue that I think it'd have to be a little bit of both.
So I'm going to sort of, unfortunately, give a little hint to your colleague sitting on the other side, which is, does that mean that you think that's basically somebody from DCJIS has to testify?
No.
How else would somebody know the record-keeping process of DCJIS?
Well, I mean, you would have to go through, you know, the same training that Dad went through, right? Dad was a police officer before.
Dowd was a DCJIS.
But I'm saying before he was, he worked for DCJIS for CJIS for what, 6 months before he testified? It wasn't like he's like a storied career, right? He was a state police officer and then moved to CGIS. So I would argue that if someone gets training to say, okay, you have the firearm licensing authority, we take these applications, we put them in, we use Soundex, we go through all these measures to make sure that those records, that output of the search is then correct. I don't think whether they're CGIS or state police or local police makes any difference, as long as they have some sort of understanding of that process. Without an understanding of that process, you can't, to Justice Rubin, you can't really cross-examine anyone. All they can say is, yeah, I used this database, I used Google, and I got this, you know, I got this output.
What if it had come in under Section 79 as a business record exception where there was an affirmation that says, I'm familiar with the record-keeping process and it was kept in the ordinary course of business?
I think you would have to have someone testify that I think the courts, if I'm not, might be incorrect, but I think the courts have said that that is okay if you have the witness that did that search. That's what, I don't think I'm mistaken, but I think in, you know, prepping for this, I think that's what the courts have said is okay at that point. Kind of like a drug certification kind of thing.
Because I'm going to ask the Commonwealth about this. Just getting to the point of his familiarity with doing the searches, right? He said that he used this database when he was a military officer in Iraq. I think so. That doesn't make any sense, right?
I mean,
there's no reason why a military officer in Iraq would consult a Massachusetts database, right? That he's confusing this with a different system, the federal CGIS system, right? When he said the FBI maintains the system, that's not true either, right? So he actually lacked a fundamental understanding of how this database works.
I think so. I think, and again, and no fault to the Commonwealth or the judge, we were really at the cutting edge, like one of the first trials happened after Guadardo, so I understand, obviously it's been fleshed out more now, but I agree, Perez was just there to say, I did a search. I don't really have any fundamental understanding of CGIS or how it's maintained and what's in there and how it's reliable. Your Honors have nothing else? That's it. The rest of my briefs. Thank you.
Thank you. Your time has expired. Excellent argument. We will hear next from Attorney Payne.
Good morning. May it please the Court, Cynthia Payne for the Commonwealth. The Commonwealth is asking this Court to affirm the defendant's convictions and uphold the sentences that were imposed by the trial judge. The trial judge properly allowed Detective Perez to testify in regards to the defendant's date of birth, name, relative to whether or not he had a firearm license. In regards to Quentin Smith, the Commonwealth would suggest that Detective Perez was both very familiar with the process of searching the database, and also he was familiar with the public record keeping practices of that database.
I'm sorry, I just get to the critical points. He was asked on direct, are you aware, have you been trained on how records are entered into CGIS? Answer, I'm not sure how they're entered. And then on cross, he said he's never been to where the records are kept. He doesn't maintain the servers or the computers or even know how they contain the records. That was his testimony. He said, I don't know how these records get in. I don't know how they're maintained. And that's a critical part of the foundation that needs to be established under Smith, right?
Well, I mean, public record keeping practices, I think that's somewhat open to interpretation. And here, Detective Perez testified that he had to undergo certification every 2 years, and that certification, part of which was who had access, how it was managed, how the database was managed, what information could be shared, and with who. And that's
Counsel, isn't that every police officer in the Commonwealth of Massachusetts gets certified to use CGIS?
Well, they have to undergo a training.
But my question is, isn't every police officer certified to do that?
I suspect so.
So is your argument that every police officer in the Commonwealth of Massachusetts can testify under Smith?
Under Smith, if they have run searches, if they ran that particular search that they testified to, I would suggest yes.
How do we get to, as I asked your colleague on the other side, I break down Smith to two things. Number one, the witness has established that he is familiar with the process of searching the database. I'm going to assume that certification is good enough. They know how to put a person's name in, they know how to put a person's database in, boom, the record comes out. Number two, adequately establishes that he understood the relevant government record-keeping process. That's what Justice Toone is asking about. What in this case shows that that second element, if I can say it, was established by the Commonwealth?
I would go back to the transcript on page 64 of Detective Perez's testimony when the prosecutor asked him about the recertification and what that entailed. And I would argue that that went to, in part, to record-keeping practices as to who has access, how it's managed. That's exactly what he testified to. Also, the Detective Perez testified that he was aware it was an encrypted system, that it required a secure login, a password.
No one's blaming the prosecutor, Detective Perez. This was Guardado just come down. You didn't have the benefit of Smith. We just have to apply that case as it exists. So there's no blame here. But he testified that the FBI maintains this database, and that's not true, right? Would you agree the FBI does not maintain the DeCegis maintains this database? They may contain FBI records. The FBI doesn't maintain that database, right? So that's not true, right? And then he said he used this database when he was serving as a military officer in Iraq. That's not true, right? Military officers in Iraq don't consult the Massachusetts database, right? That's totally he was confusing that with a different federal database. Isn't that true?
I can't speak to that.
Okay.
I don't.
It's implausible. Would you agree it's implausible that military officers in Iraq use the Massachusetts DeCegis database for their work?
Probably highly unlikely.
Okay. So it seems like there is a fundamental misunderstanding on his part. And again, no blame to him. They're trying to do the best they can because there's a new requirement coming out about have to affirmatively prove the absence of a record. But it just doesn't seem like there's enough here. And what's the evidentiary value of testimony about the absence of a record in the database when there's no testimony as to what records are in that database, how they're maintained, how they're verified, things like that. That goes to the weight of the evidence ultimately.
And again, the only thing the Commonwealth can keep coming back to is his testimony, and it was sparse. I maintain, and he had indicated he didn't feel well, and
Well, but no one asked because they didn't have Smith. They didn't know they had to ask in any detail. I mean, it isn't a fault question. This is one of these weird cases where while the appeal was pending, a case was decided that tells what you have to do, and nobody knew. Clearly, the Commonwealth was trying to make sure that it had adequate evidence, to demonstrate lack of licensure. The closest I think I get is not on page 64, but on 82 and 83, were you trained on CJIS at that point when you started working at the Springfield Police Department? Yes. That doesn't, I don't know how much that undermines that it's an FBI thing. Like, I don't know. I assume he was trained something about that. And then he says, the question is, have you spoken with the records department? This is to find out how records are entered. And he says they're entered through reports that are gathered from the police department, say on stolen motor vehicles or stolen weapons or any other reports. I mean, that seems to me like the strongest thing. He says police departments or the police department enters them. I don't know.
I agree, and I would also suggest that in doubt, I mean, the court made it very clear that the person who testifies does not have to be a DeCegis employee.
In Smith, right? In
Smith.
Right.
Thank you. Thank you. It was officer. Yes. I would also, I know this goes more into the other issue, but in Dowd, in Smith, there was an objection as to the defendant's date of birth because of lack of personal knowledge, because the district attorney's office had provided the employee with that, as opposed to here.
I don't want you to think, based on my question, I think it was to your colleague, that it has to be a DCJIS employee. However, figuring out where the goalposts are after Smith seems to be very important. Certainly, or maybe not certainly, but presumably, if an officer from Springfield who is in charge of issuing firearm licenses, who's probably, based on some prior knowledge I have, is probably the one that sends the information to CJIS, that person might be qualified to give part 2 of Smith, how the record-keeping process is of licensing authority. So do you think that's what the Commonwealth needs? Somebody who knows, to go back to Justice Toone's question, who knows how does that firearm license or lack of license get to CJIS in the first place?
Well, I certainly think at this point, the Commonwealth will be speaking with their police officers much more in regards to, their knowledge of how records are enter.
And the trainings may already tell them, but no one was paying much attention, right? I have no idea it may be that every cop knows that every city and town enters every license issued into the database. I guess that's what's supposed to be adequate, knowing something like that. Presumably so that then someone could reach the conclusion beyond a reasonable doubt. So if you find nothing in there, they don't have a license. Can I ask you about the sentencing? Because I have a question about that. The defendant was not convicted of murder in the first degree. The defendant was not convicted of murder in the second degree. The defendant was convicted of voluntary manslaughter, which means either, if I'm not mistaken, you'll correct me, but either that he was acting in self-defense but used excessive force, or that he was acting in the heat of passion or due to sudden combat. I don't know that this is a heat of passion case. I'm not sure how it was argued, but maybe it was a sudden combat case. Although, again, I'm not totally clear on what that exactly means, like what the scope of that is. But one of those three things had to have happened. Now, to me, all three of them, the reason it's not murder anymore is those mitigate a homicide, culpability for a homicide. If it's self-defense and you use too much force, that might mitigate it. If you're at heat of passion, that's supposed to mitigate it. I mean, there's theories about the validity of all of this, right? And sudden combat is supposed to mitigate your responsibility. So the judge says, in sentencing, nor will I read into the jury's verdict on voluntary manslaughter to somehow divine that they believed that there was a degree of innocence or self-defense on the part of Mr. Eberhart. But isn't that what this conviction means? That there was a degree of innocence or, lessened guilt, or that there was self-defense? And when the judge says, I'm not going to think it means that, isn't the judge ignoring what he was convicted of and what he was acquitted of?
I would say no. I mean, I think it was very clear that the judge acknowledged that this was a voluntary manslaughter verdict. And I do believe, I would say that the judge didn't want to speculate as to the reason that I think it's difficult looking at a jury verdict because
we don't know which of the three, but we know one of them. I mean, of course, in real life, juries compromise, they do stuff right, but we don't look at that.
Exactly.
But when we get to sentencing, we have to look at the elements that they concluded were proven, right? I mean, we don't ignore what they were convicted the person of. So, I've already asked the question, I guess. I understand that I understand if he said, I don't know which of these it is, that's something. But he's saying, I'm not going to say it means either some degree of innocence or self-defense. But doesn't it mean some degree of innocence or self-defense? Otherwise, it'd be murder.
Possibly, but I would suggest that the trial judge properly sentenced the defendant Certainly manslaughter is a 20-year felony. The trial judge, the Commonwealth's recommendation was 18 to 20, and the trial judge, he was sentenced to 14 to 16, I believe, and then on and after time.
With an on and after of 3, I think? I don't remember.
On and after, not more than 3, not more than 2, not less than 3.
Okay, and you said 18 to 20, but concurrent, right?
It was 18 to 20 on the voluntary, and then
Everything else was concurrent.
everything else was, no, consecutive. The other 2 charges were consecutive.
In your recommendation, okay. I mean, I'll have to look, but. I can look, we can look.
Yes,
It's
it was
fine.
consecutive, Your Honor.
Okay.
That's my recollection.
Okay.
I would suggest that the trial judge he referenced the sentencing guidelines, he referenced the best practices in sentencing, and the fact that he made possibly that one comment, I would suggest, which is unknown why or what that he meant, but that he properly sentenced the defendant. Unless the court has any further questions.
Well, I do actually about this. If we were to conclude that the sentencing was improper, do we have to, and to remand it for resentencing, do we have to send it to a different judge, or can we send it to the judge who heard the trial evidence?
Well, at this point, we'd have to send it to a different judge because that judge has retired or is no
I
longer
see.
on the bench.
Okay. I have no further questions. I see no further questions. Thank you. Excellent
Thank you.
argument.
Thank you.
The next case we will hear is Commonwealth versus Lopez. That's number 24177. We'll hear first from Ms. Lindmark. Whenever you're
Okay.
ready.
Good morning, Your Honors. May it please the Court, I'm Attorney Lindmark, and I'm here today to argue, obviously, on behalf of Mr. Lopez. We have 2 issues in this case, both involving the improper seizure of items found in his shared bedroom. It's our position that a pretrial motion to suppress was improperly denied, and that a post-trial motion for required finding was also improperly denied. Starting with the first issue. Ultimately, this seems to be a question as to whether Mr. Lopez had a reasonable expectation of privacy in his bedroom.
Counsel, can I ask you sort of a procedural question? I want to make sure I understand what was sought to be suppressed and what you are arguing should have been suppressed. You're not arguing the drugs should have been suppressed, correct?
At this point, no.
Any of the drugs?
At this point, no.
Okay? And the mother could have testified, regardless of police involvement, that she went into the bedroom, found a pair of pants as described by the defendant, and inside those pants she found drugs. That would have been permissible testimony.
That was what she reported to the police, so yes, I would assume
Okay?
so.
So the only thing really what we're talking about is the paperwork that has the defendant's name on it, right? Because, again, that may have been suppressed, and the mother, there's no evidence at all that she saw any paperwork of the defendants.
You're referring to the articles of mail?
Yes.
Yes. And my argument today is that also the pants were improperly seized.
Okay.
And they were
the
DNA.
actual pants. But she could have testified about there were pants there, and inside there were male pants, and inside the pants there were drugs. That would have been permissible testimony. It's just that the actual pants themselves wouldn't have been able to be admitted, or that the police said when we went into the bedroom, we found pants, right?
Correct.
Okay.
So It was interesting to me just recently realizing that she is not the police, and there is no argument actually that she violated his constitutional rights. The Commonwealth in its brief cited 2 cases dealing with this, and in my opinion, the operative language being, unless state officials have instigated or participated in the search, that there is no argument there. We are arguing, we're saying it certainly is arguable that the police participated in the search, followed up the very next day when they came to the condo, seized evidence, including the pants where the drugs were found, and a seizure of the baggies containing the drugs. Once the police were on the scene, there was no effort by them to obtain a warrant, we know that, supported by probable cause. They seemed to rely on permission to search, which they obtained from the mother. They searched the bedroom, seized the pants, and so forth. So the legal standard here, my understanding is, whether the police intruded on a constitutionally protected reasonable expectation of privacy. The judge who decided the motion to suppress said that he had no reasonable expectation of privacy. Our position is, following the case law that's been established in Carter, Commonwealth versus Porter, other cases, that he had a reasonable expectation of privacy in his bedroom, and the police were obligated to get the warrant. He had been sleeping at this house with his girlfriend for most of the past 6 years or more. He had his clothing there, received mail there, had items stored in the garage. As the Porter case establishes, the fact that he did not own the room or condo and that others could enter the room would not diminish the legitimacy of his privacy interest in that room.
The door's unlocked. The mother has free access to the house and the room, in and out whenever she wants. So why is there an expectation of privacy?
Well, I think one of the determining cases, which was cited in my brief, is U.S. Supreme Judicial Court case, Minnesota versus Olson. And in that case, they clearly established that a guest who stays but one night in a friend's house with or without a key and with or without paying rent has a legitimate expectation of privacy in his host's home.
But someone else does as well, right? The host also presumably has a legitimate expectation of privacy, or if 2 people share a bedroom, they each have a legitimate expectation of privacy. But in some circumstances, one of them can consent to a search, even though what's going to be found in the search is relevant to the other, right? We have common authority cases that say someone with common authority has actual authority to consent. So presumably someone who presents themselves as having common authority has apparent authority, I would think. Is this a common authority case? Did the mother have common authority over that bedroom, assuming there was an expectation of privacy?
She had authority over the condo itself, but that authority, we are arguing, did not extend to his private area in that bedroom, even if she had access to the bedroom, even if she had a key to the bedroom.
But he didn't have a key to the bedroom.
He did not have a key.
Well, it's not a locked, there's no lock on the door. I couldn't find, there's 8 photographs mentioned in the transcript that are, I don't see them in anything that's been given to us. I gather one of them is a picture of the door. I don't know if the door was shut, open, because I don't have the picture.
It was my understanding, just reading the transcripts, that the door was shut but not locked.
I don't see that
And
in the transcripts.
that's how they lived and had been living for some time.
And we also don't know what it was like when Mom went in first. Does that make a difference? What if the door was open and Mom shut it after she took the drugs?
Well, there's a lot of what-ifs with what Mom did. And we also have the argument that, in fact, Serena was probably the owner of these drugs. 2 of the packages were found on her desk. She was the last person in the bedroom before she was ousted.
You can tell the jury that, right? That's not
Right.
nothing to do with us.
I agree, Your Honor.
Does, even if there was an expectation of privacy, which I'm not conceding for purposes of today, but let's assume there was, when the restraining order issues, which prevents Serena from going in, and she says to the defendant, you're not welcome here anymore, doesn't the expectation of privacy end at that point? I mean, it doesn't go on forever, does it?
I do not believe it would go on forever, Your Honor. However, he had no idea that any of this had transpired, and arguably, it would be perfectly reasonable for him to be given time to go in and get his things.
So in a restraining order, again, I couldn't find a case about a restraining order being in place. So if a defendant has let's say it was Serena who came to the apartment. She's not allowed there. Mom says, go away. How long does the expectation of privacy last in that circumstance? At what point can mom just say, I'm walking in, or police, sure, come on in. She's not allowed here.
I don't have a case to definitively decide this. However, in my opinion, he should have had the chance to go in, get his things, and then leave forever. But up until that point, he had an expectation of privacy. Once he realized what had happened, that Serena was out, which he clearly did not know, he said, I'm going to call Serena.
Well, here's another interesting fact. When there's a restraining order, somebody can only go in the company of the police. So the police would have walked in with the defendant with the drugs on the counter.
There's no restraining order against the defendant?
There was no restraining order against him.
Okay.
It was against Serena only. So
But she did say, I'll only let you in with the police accompanying.
correct.
Right.
At which point he said, I'm going to call Serena.
I guess just to reframe one of the questions that Justice D'Angelo is asking is, did the mother's authority change after the restraining order was entered in terms of her authority to enter this room, or was it always the same in your view?
Well, I think she had a broad common authority.
Authority to consent to the police going into
Consent
yeah.
to the police coming in and searching. She did not arguably have what was required, which I think was apparent authority.
Wait, you're saying she had actual authority to consent to a search of the room?
She had authority to tell them generally to search the apartment, the condo, but not specifically that room.
Okay. I mean, I'm just thinking about a situation where there are tenants in a bedroom. And I would think that if you wanted to get them out, you could evict them. And at some point after they've been given due warning that they're being kicked out, then maybe they don't have any expectation of privacy. But the day you tell them you're evicting them and all their stuff is in there, it doesn't suddenly mean the landlord can open the door up and say, oh, go look through their underwear drawer or whatever. I wouldn't think. I would think some time would have to pass and something would have to happen. Now, maybe the restraining order is enough for telling him he can't come in, but I mean, I don't know, you know what I mean? I don't know where the line is, but I don't see how it can be, if they were tenants, how a landlord saying you can't come in here anymore would make their apartment or if they were renting their bedroom that they were renting, no longer, now anyone can come in.
Well, I don't think a landlord would have the authority to do that just verbally, quickly, and say, that's it, you're out, and...
Well, people kick people out of things all the time,
Well,
whether they have the authority or not.
That's why there's a land court. Right?
Yeah.
I think these are complicated questions, I agree.
Well, this is sort of a follow-up to Justice Rubin in the sense that I have no idea what the defendant's status is in this place. He's not a tenant. He's not the daughter of the mother. So, yeah, he's not listed on the restraining order because I don't even know whether he's supposed to be there at all. Does that play into any role regarding an expectation of privacy?
Wow, that's interesting.
I mean, what is he? It's
Well,
mom's house.
He's someone who
He's a
had
guest.
been with her approval, I would assume, for over 6 years, 6 to 7 years, been living there.
So he's a guest, like the case law talks about, somebody who's a guest. Doesn't that guest's expectation of privacy end when owner says, you can't come in here anymore. So while he's a guest, and this goes to the other cases, somebody is a guest, you can't go into that room without the guest's permission because they have an expectation of privacy. When that restraining order entered, or at least when he comes back to the place and mom says, no, you can't come in, he's no longer a guest, is he?
Our position would be he has the right to get his things and leave at her order.
Under what
but he has a
legal
right
authority does he have a right to go get his stuff?
his expectation of privacy and all of his things.
Okay.
I mean, there was one case, I
Is there any
can't,
case law that talks about somebody who's a guest has a expectation of privacy after he's no longer a guest?
our position is he is still a guest until he has his things, has an opportunity to take his things. His expectation of privacy still exists.
Can I ask you this? Whose burden was it below to show what his status was?
Could you repeat that? I'm sorry.
Whose burden was it to show what the status of this person was?
I would argue it would be the Commonwealth's burden.
Isn't it the
They have something
defendant
to
who has
prove.
to show that he has an expectation of privacy in the location to be searched?
In a defensive way, but if the Commonwealth is asserting something against him, they initially have to try to establish that he had no expectation of privacy.
Really? Do you have a case that says that?
I'm sure, but
Well, they have to justify their warrantless search, right? I
Yes.
mean, once you say it's a warrantless search, I think the burden shifts to them. I may be wrong about this legal question, I don't know. But I would have thought they'd have to show everything. There was no expectation of privacy here, and if there was consent, and if there was, it was based on actual apparent authority, I would think would be their burden. But we'll ask your opposing counsel.
And I think my time is almost up. Should I push on to another issue, or should I rest on my brief?
You got 27 seconds.
I'll rest on my brief.
All right, thank you very
judges.
much. Excellent argument. We will hear next from Mr. Punch.
Good morning. May it please the Court. Assistant District Attorney Dylan Punch on behalf of Middlesex County for the Commonwealth. The Commonwealth asks this Court to affirm the judgment because this search did not violate the defendant's rights and there was sufficient evidence that the defendant possessed cocaine and he had the intent to distribute it. Now, as to the search of this room, even skipping ahead of his expectation of privacy, this was a valid consent search. The homeowner had both actual and apparent authority. This was not a private bedroom belonging to the defendant in her residence. This was a place where he slept on and off. It was his daughter's bedroom. It was a shared area where the homeowner accessed freely. She stored her personal belongings in there. It was an unlocked and...
Does your analysis change depending on the 2098 order being entered and the daughter being excluded, or is your analysis the same all the way through because the mother was able to store boxes in the room?
I think the analysis remains the same, Your Honor. The fact that the daughter was no longer welcome there certainly put the defendant on notice that he no longer could enter the apartment and thus should not have had a subjective...
But your argument is sort of the mother always was able to go in whenever she wanted
Correct.
to.
Even before the restraining order issued, Your Honor. She said she had full and free access to this room. She also...
She said she had access. She didn't say full or free.
Well...
She said she had access to the room and she stored boxes there.
Correct.
Well, you'd have to have access to the room to store boxes there.
Correct.
But it's not clear to me that that's run of the room. Maybe she can just go in and get her boxes.
I seem to recall the word free in there. I may have that wrong, Your Honor. But she does go into this unlocked room. It's a shared space. This is not the defendant's private bedroom. Now, as to his expectation of privacy, he couldn't even access this residence without permission. He didn't have a key to the unit itself.
I rent a hotel room. I'm the guest there. I put a bunch of stuff there, some boxes, a briefcase. Well, briefcase might be different, but I put stuff in the drawers. Personal stuff. We know that that's my home under a lot of Supreme Court decisions while I'm staying there. I come back to go in the room, and I find that my key card doesn't work anymore. And the manager says, you can't go in there anymore. And I said, well, all my stuff is in there. He's like, you can't go in there anymore. Please leave. And I do. I no longer have an expectation of privacy in my personal stuff in that room. When I had no notice, listen, your welcome here ends while you're out of the room tomorrow. How could my expectation of privacy vanish like that just because someone who themselves don't have access to the room is telling me I can't come into the premises? I mean, I understand eventually it has to, but I don't understand how it can be extinguished with no notice or warning by a private person telling you don't come in here.
Well, in that example, Your Honor, arguably the expectation of privacy would not extinguish. Now, if it was someone you rented the room with who was staying in the room, and they said, I don't want you in here, and you left, and then they later called the police, said, I found drugs in...
No, of course, if you're in the room and they say leave, you can gather up your things, put them in whatever you brought them in, or carry them out, whatever, and you go. And you don't, every time, when you check out of a hotel room, you don't have an expectation of privacy. And if you've been foolish enough to leave something terribly incriminating in the back of some drawer, and someone finds it, then, well, whatever, luck of the draw, right? But I'm just trying to, because the guy slept in this room for 6 years. And it doesn't sound like, I think that, well, actually, let me ask you, do you think the burden is on you to justify the warrantless search? Or do you think the burden is on the defendant to demonstrate an expectation of privacy?
Your Honor, when a defendant is challenging a search in the constitutional sense, they bear the initial burden of establishing that they had a reasonable expectation of privacy in the area.
Do they, or do they have the burden initially to show you searched without a warrant? And then you can say, yeah, but there was no expectation of privacy.
My understanding, Your Honor, is that they have the initial burden just to say that they had the reasonable expectation. That's from Commonwealth versus Carrasquillo. That's 489 Mass 107 at 117. And that was my understanding.
489 Mass?
489 Mass 107 at 117. That's Commonwealth versus Carrasquillo. But in any event, his expectation of privacy here, it really comes down to that Rubin had actual and apparent authority to search. So even if he did have that, she consented to the search, and the police had no reason to doubt that she had actual authority, so she did have apparent authority. She said, he's not allowed, this is my daughter's girlfriend, he sleeps in this room on and off for 6 years, he doesn't have a key, they know the door is unlocked, she says, I store my things in there, and she says, you're free to search. She signed
I'll have to look at full and fair. If she said she had full and free access to the room, that's a little different than I have access. I may have missed that. I just thought it said, she said she had access and indeed, she stored boxes in there.
I recall the phrase free access, Your Honor, and I don't want to hang my hat on that specifically, but she did say this, she stores her belongings in here. Now, as to the sufficiency of the evidence, here, there was certainly sufficient evidence that the defendant constructively possessed those drugs. They were in a pair of his pants. There was the large bag of approximately 40 grams was in a pair of his pants. There was 2 smaller baggies in plain view. There was also articles of his mail bearing his name. There was testimony this is a room he slept in on and off for 6 years. When he showed up to the residence, even though he had other valuables there, power tools, workout equipment, other clothing, he wanted this specific pair of pants containing the cocaine. And as to
there was testimony about the value also.
It was, yes, $2,500 worth, Your Honor.
And did someone say that's consistent with distribution?
They did say that it was a quantity consistent with distribution, Your Honor. If I remember so moving on to the sufficiency on the intent to distribute, I believe the testimony is that in street-level drug transactions for personal use, it's between 0.5 gram and 1 gram bags. So the jury was aware that he had 40 to 80 times more than would be consistent with personal use. There were testimony that was packaged in a manner consistent with intent to distribute, and that a source supply bag, 2 smaller bags, and there was no implements that would indicate personal use.
If we conclude that the search was improper, and I think what we got is it's really only the mail that wouldn't have been able to be testified to, because the mom could have testified as she did about the drugs in the defendant's pants, the fact that he lived there for on and off for 6 years. If we say that the mail, in essence, should have been suppressed, Do we have to reverse?
No, Your Honor. The mail was merely cumulative, had limited evidentiary value, especially with the homeowner saying, yes, he has stayed here on and off for 6 years. I found cocaine in his pants. I believe there was more than sufficient at that point.
Were the sneakers admitted?
I don't believe the sneakers were, Your Honor, if memory serves. I believe it
Okay,
was
so
just
it's the pants themselves, and presumably the DNA testing of them that showed they were his, or that his DNA was on them, right?
I don't believe they found DNA on the pants. I believe it was inconclusive.
Oh, so
Your
it's
Honor.
just the pair of pants, just like
The physical pants, the physical pieces of mail, then presumably any officer testimony or photographs about what they saw or photographed while they were in that room, Your Honor.
Have you looked at the 8 photographs?
I have not, Your Honor. I just read the description in the transcript.
I see, okay. I'm just wondering if the door was shut or open, although, of course, it could have been the mother who shut it subsequently, because she had been in the room most recently.
Correct, Your Honor. What I got from it is just that the door did not even have a lock on it.
I understand
Can
that.
I go back to the expectation of privacy for a second? Again, I don't think there's a case on it, so I'm asking you what your opinion is.
Yes, Your Honor.
At what point does someone who is, we'll call him a guest, lose an expectation of privacy, either because he's kicked out of a hotel room, or in this case, because there's at least a restraining order that the other occupant can no longer go there, and mom says, you're not welcome here anymore?
Yes, Your Honor. So I believe the closest case I could find to this, this was Commonwealth versus Mallory. It was 56 Mass App Court 153. This is a 2002 case. And this was a case where he was a guest. He was staying in this family's home. He sexually assaulted the daughter. When the father found out, the defendant absconded through a window, ran away, and the court essentially said that his expectation of privacy disintegrated because he knew he was no longer welcome there. Now, I would posit that this is similar. However, the difference being this wasn't a case where the defendant couldn't get his stuff, he was locked out, don't come back. He had full opportunity right then and there. The homeowner said, call the police, you're welcome to take anything you want, and he opted not to do that, presumably because there was drugs out in the open.
Right.
But he did have the chance to get his property.
56 Mass App Court 53?
153, Your Honor, Commonwealth versus Mallory.
Very good, thank you.
If there's nothing further, the Commonwealth will rest on its brief.
I see nothing. Excellent argument. Thank you very much. The case is submitted. We will next hear Commonwealth versus Bonia, number 24818. After this case, we'll take our traditional mid-morning break, to the extent anyone needs to know that. And we will hear first from Attorney Oresti.
Good morning, Your Honors. May it please the Court, Attorney Megan Oreste for the defendant appellant, Ms. Amanda Bonia. This is a case about a dog on the last days of life. And even under the stringent Lattimore standard, we argue on appeal that the facts of this case, regardless of the theory that the Commonwealth pursued at trial, are insufficient to sustain guilt beyond a reasonable doubt that Ms. Bonia committed animal cruelty by either intending to subject her beloved Kayla, her dog of 15 years, to suffering, or intended the act that caused the suffering. We argue on appeal that the Russo case applies. This case is very similar in facts to Russo, where you have an elderly animal that's clearly in the last stages of life and in rough condition. Like Russo, Kayla was most likely close to death, very thin frame with very shallow breathing. Tipper, the dog in the Russo case, was arguably in even rougher shape and had open wounds and open bed sores and large necrotic masses.
It's a similar set of facts, but it's a different provision of the statute that's charged,
Yeah.
right? So that's the problem here. And then we addressed this part of the statute that we're dealing with here in Erickson, right? In Erickson, we said you don't need knowing and willful conduct. The statute simply requires that a defendant intentionally failed to provide the animal with food, drink, shelter, or some of the other basic needs, right? So doesn't this take it outside of Russo, which is dealing with a different provision about intentional cruelty?
I completely understand what you're saying, but I think to step away from Russo with the facts being so on point and the SJC coming to the conclusion in Russo that this statute, the legislative intent was not to penalize somebody for not intervening at the end stage of their dog's life, I think that applies here. I do, however, argue, and we do argue strongly on appeal, that even if you take that specific intent of Russo away, that Ms. Bonia did not, the evidence was insufficient to show that Ms. Bonia had denied this dog sustenance.
Well, can I ask you, so let's assume that Erickson's binding, and it has to be that the defendant intentionally failed to provide Kayla with these things. What does that mean in your view? What is the intentional failure? What does that require? Obviously, there has to be a deprivation of what it needs, but what is the intent requirement?
I think the
How
intent.
does it translate to this case?
I think that's a general, if you're looking at Erickson, it's more of a general intent in that she intended the acts of not providing water or shelter. However, I think that the evidence in this case shows that she did care for this dog. And if you look at Erickson and just the facts, stepping away from Russo and looking at the more general intent position, in Erickson, you had a stench-filled apartment littered with trash. You had overwhelming evidence of neglect, including abandonment, lying in their own filth, overflowing litter boxes, and emaciated dogs. And in this case, you have a dog that's lying outside on a 70-degree day, a husky coyote mix that preferred to be outside, that is at its end stage of life. And you have testimony from one neighbor who says they saw the dog for an hour or so that day, Miss Ferrara, and that she can't see the porch from her yard. She doesn't know how long the dog has been there. And then you have another neighbor that says he mowed the lawn over 15 years, and a couple times the dog's water bowl was empty, which I would argue the inference that there was a water bowl was that the dog, if was outside for a long time, was given water. I think what this case presents for this court is the question of sufficiency. Lots of dogs are in rough shape at the end of life.
Sure.
And are thin and I think when you look at the cases where sufficiency was deemed to be had, you have the case like Waller, 90 Mass at 295, where you had a vet testify that the condition, the thinness of that dog was not because of, was because of starvation and not end of life.
Let's focus on one day, okay?
Mm-hmm.
The statute talks about failure to provide, quote, adequate food and water. What does adequate food and water mean? What if a dog in this circumstance had water in the morning at 75 degrees and by 11 o'clock the water's gone? And it's a hot day, again, we can argue 70, 75 degrees. Isn't that adequate if the water runs out in the early morning?
I think the challenge is we don't have the evidence here that the dog had even been out for that long, and most people keep their dog's food and water bowls inside. And so you don't have testimony in this case that the dog was outside at 7 in the morning. I think Ms. Ferrara, the only evidence from the witnesses was 2 hours maybe at most.
The question is, doesn't that leave it to the jury to decide what, quote, adequate means?
I think that, yes, it's definitely a question for the jury, but it's still on appeal, it's a question for sufficiency.
Couldn't the jury in this case have found that when the neighbor shows up at whatever time, 4 o'clock, and the water is out in this degree of heat, that's not adequate? That's a jury question. You might not agree it's adequate, but for sufficiency in a light most favorable to the Commonwealth?
I don't understand why you're conceding it's a jury question. We're going to, people who don't refill the water bowl are now guilty of cruelty to animals.
Well,
I don't know what the punishment is for that, but I'm guessing some of it could be serious. I would have thought that your answer would be, it's not sufficient to support a verdict. The jury doesn't get to decide.
I think it's a question for the jury to consider. I do not think it's
What's the point of them considering insufficient evidence? I don't understand.
Well, I think it could be considered in light of all the other evidence, but here we don't have all the other evidence supporting neglect.
You haven't talked about the report from the vet
Yes.
that finds the dog emaciated, medium to severe, moderately to severely dehydrated.
But I think, again,
We can
if
sort of
you-
stick with those, although it also shows a lot of other, hair missing, Now, my question is this. You say it's the dog's end of life. Can't a jury conclude no? Right? Like, even when dogs die, they're not emaciated and dehydrated. I mean, maybe they are, I don't know, but.
Well, and I do think that the jury could consider the report, but I think if you look at Russo and you look at the other case law where sufficiency is found, just having a dog deteriorating at the end of life, being thin.
Although the end of life may be caused by the deterioration, right? You can starve someone to death.
But I don't think the evidence is sufficient here to show that. When you look at the other case law that reaches that conclusion in terms of evidentiary support, you have the vet testifying. You have a necropsy, which is a dog autopsy. You have other evidence that it wasn't old age, that's the condition this dog was in.
Let me try to summarize all the evidence, because we'll ask the Commonwealth about the shelter issue, which I think may not be sufficient. But the drink issue, right? You have the one neighbor who mows the lawn several times, at least an hour at a time. Every time he sees Kayla outside, no water in the bowl, right? Then on the day of Kayla's death, you see both neighbors see Kayla there with an empty bowl, and then the animal control officers come, take it away, and the reports show she's emaciated, moderate to severe dehydration. So that's the totality of evidence about drink. And you're saying that's not sufficient to support?
That's not sufficient. I would argue that that would be even less sufficient after the defendant's case, because Ms. Bonia testifies that the dog had stopped eating and drinking well for a couple of weeks. The dog was at 15 years old.
Is that excuse not putting water out next to Kayla?
Well, she testifies that she had water and food out all the time inside for the dog, and that the dog had stopped, and she had called the vet, and the vet said $500 just to be seen. She didn't have the funds, and she had called Carver and Wareham Animal Control and asked for help, and the animal control officer testifies, we don't help with euthanizing dogs. So I think that there's no consciousness of guilt. If anything, even more so than the facts in Russo, that you have a defendant here who was actively trying for the dog not to suffer,
I guess
looking for help.
When you say consciousness of guilt, that's introducing a new standard here. And it gets back to my initial question of what does intentionally mean here? Is there enough evidence of people seeing a dry water bowl on repeated occasions? Is that enough to establish an intentional deprivation, or do you need something more, and what is it?
I think you definitely need something more. I think if you had, I can speculate, but I would say, like, if this was a case where you had this medical report and it was a puppy, but this is an older dog. This is conditions older dogs can be in. And I think also that the legislative intent for the statute is not for, someone who's been a pet owner who, yes, animal control had been called. Her neighbors, maybe the dog barked, didn't like the dog. But every time animal control came, she testifies, there was never a reason to take possession of this dog. The things that she didn't comply with were licensing, had nothing to do with providing food and water. And
well,
when
she said the dog needs a shelter, and
she bought her a doggy igloo. Yes. And my client testified she was a husky coyote mix. She laid outside of it because outside was her natural environment. So we looking at the facts of this case, at the weak testimony regarding over 15 years, there were some licensing issues, and we saw the dog. He mowed the lawn 3 to 4 times. That's what he said, over 15 years, and there was an empty water bowl, which I think you could equally inference that meant that there was water in the bowl.
But sufficiency, we got to give every reasonable inference in the government's favor. That's the problem here, right? Like, it is not, it seems to me, not a strong case, but is it a case that takes it away from the jury and mandates a required finding of not guilty, or is it enough to go to the jury and have them make a judgment and say, hearing all the evidence, we think that there was an intentional deprivation here?
I think in this case, I would say for the court to really consider the legislative intent of what they were trying to protect animals for with this statute, and with the scan evidence, does it rise to being able to show that she intended these acts to deprive this dog. And the fact that they brought in the dog officer and medical records and showed no evidence of over the 15 years that there was ever an issue with this dog being thin or in any other condition other than these last days of life. I don't think this is facts that the legislative intended to criminalize, especially when she testifies, I call it deterioration, and shows that she was really trying to get help for the dog. She knew the dog was in rough shape.
Well, her testimony could be disbelieved, right? I mean, that's not really...
I think, though, even under Lattimore, the jury really had to make, some guesswork here, had to guess and surmise that the dog was in this shape because of neglect versus because the dog was 15 years old, that the dog would have drinking water if there was a bowl and wasn't refusing water because. So I think there was a lot of guesswork, and I think even under Lattimore, the evidence just does not meet sufficiency for a finding of guilt.
Can I ask you a hypothetical? I was on the panel of the Russo case with Tipper. I think I asked this same hypothetical then. The vet says this dog is suffering. It's old. It should die. How much will it cost, the owner says? $500. I don't have $500. Okay, I can't euthanize it. It's suffering every day. Owner takes dog home and says, I just want the dog to die. I'm not going to feed it because he's suffering by staying alive. And she lets the dog die from not eating and drinking. Is that a crime?
I don't think that the statute meant to criminalize that particular set of facts.
What do we do with that? The statute says failure to provide adequate food and water. The owner basically is saying, I'm not providing adequate food and water because I want it to die because it's suffering.
Yeah.
It fits into the statute, doesn't it?
I think that
isn't that this case?
I don't.
Maybe.
But I think that honestly, I think on the facts of this case, we don't even get to that point because I think Miss Bonia testifies that she really knew the dog, and the dog had stopped drinking and eating. The dog had made the decision that I'm not interested in water or food.
I'm going further. I'm giving it to the light most favorable to the Commonwealth. She doesn't even put water out in the morning. She lets the dog out.
I don't understand why you're saying that's not under the statute. Cruelly euthanizing a dog seems like animal cruelty to me. The reason we have vets do it is they do it in what we understand to be a humane way.
Yeah.
Starving a dog to death doesn't strike me as the humane way of euthanizing a dog.
But I think that in this case, she testified that there was water and
No,
food,
I understand.
and the dog denied.
I understand that the question is, did she or did she not provide water, or did the dog simply refuse to eat and drink at the end of life? I get that that's the question here.
But I think if you look at this case, the jury had to say that they had to speculate. There was no evidence at trial that the dog had been out for more than a couple of hours. So the jury had to speculate that they didn't have water and food. There was no testimony saying that directly showed that Miss Bonia did not water or feed the dog. I think that there could be a case where you don't have to speculate that, where the officers go into the home and they say there's no dog food, there's no water bowl. But I don't think you have that here. You just have a dog that loved to be outside, lying on the porch in the sun, and we don't have testimony confirming how long the dog had been out there. So I don't think that scenario is this case.
Your time has expired. I see no further questions. Thank you for an excellent argument.
Thank you. Thank you.
We will hear next from Attorney Burbine.
May it please the Court, Carolyn Burbine for the Commonwealth. It's the Commonwealth's position that the trial judge properly denied the motion for required finding at the close of the Commonwealth's case, where we presented sufficient evidence that the defendant unnecessarily failed to provide the dog with proper food, drink, and/or shelter based on the witness's testimony and the animal hospital records.
Now, the statute says unnecessarily, and Erickson says intentionally. So do you agree that intentionally is a element here, a requirement?
It's general intent, not specific intent.
General intent of what? What is?
General intent to, under Erickson and Russo, general intent just requires that the defendant intentionally failed to provide whatever it is we alleged, which here was food, drink, shelter.
So help me, explain to me how that applies here. And let's just focus on shelter, which I think is one of the weaker parts of your case, right? The evidence is the animal control officer comes and says, hey, this dog needs a shelter, right? And the defendant goes out, buys a doggy igloo, puts it out there. There's no evidence that the doggy igloo is not available. There is evidence that Kayla, being half coyote, half husky, doesn't want to use the igloo and stays out. But there is a response to the concern raised by the defendant about shelter. Do you think that's an intentional deprivation of shelter?
I do, because first of all, the testimony, well, I'm sorry, there was testimony from the dog officer that she had spoken to her about getting a shelter. Shelter, providing the shelter is, you're the owner, the dog shouldn't be dictating whether it's getting adequate shelter. You have to make sure it has adequate shelter. So if the dog, they talk about pressure points on the pelvis, hind limbs, and shoulders, which inferably means that dog isn't moving around.
But if the shelter's made available to the dog and the dog doesn't use it, you're still saying that's an intentional deprivation?
You leave the dog, you bring the dog inside. The dog shouldn't be outside all day in the sun on a 70-degree day. It's a husky with no water. It's your responsibility to make sure proper shelter. Proper shelter means if the dog won't use the shelter you're providing and the dog needs shelter, you bring the dog in the house.
Really?
You're required to make sure that it's.
You've got to force the dog to be inside, or to.
Well,
it just doesn't seem that. It seems like a very strict.
But that's what the statute says, adequate shelter. So if it's a 70-degree day.
Can you have an outdoor dog?
I'm sorry?
Can you have an outdoor dog at all?
I believe so, but I think people would say that that's, you could have people have dog houses, I don't know of anyone that, I suppose if you had a completely fenced-in area where it wasn't on a short leash all the time and it could run around, I suppose maybe that wouldn't be animal cruelty. But here in Boston, you've got 90, 100-degree days. I still think you have to bring the dog in on one of those days because that's not adequate shelter.
Let's talk about the word adequate, like I asked opposing counsel. What does that mean in the statute? Here, there's no evidence as to how long this dog had water that morning. She could have had water all day, right up until the time the neighbor looked and said, oh, the water ran out.
But the dehydration records from the animal hospital belie that.
That could have been from over weeks because the dog is dying. What is it on this occasion?
The only testimony we have that the dog was dying before this was happening was the defendant's, and we're looking at the motion for required finding at the close of the Commonwealth case, and we're looking at it in the light most favorable.
You didn't put in, I don't know if you need to, you didn't put in any expert evidence that a dying dog wouldn't be emaciated and dehydrated. I don't know the answer to whether a dog.
We didn't proceed on a theory that the dog was dying. It's the defendant who did, and we have.
Well, the dog died.
Yes, but.
And it maybe died from starvation.
It could have died from starvation and dehydration.
There's nothing in the report that says that.
But we're doing it at the motion for required finding stage where you're looking at it in the light most favorable to the Commonwealth. You're looking at the Commonwealth's presentation of the evidence, and you're looking at reasonable and possible inferences. So the reasonable and possible inferences here are you have a dog that I would remind the court that Mr. Shurtleff said he didn't see food near the dog that day, and both Mr. Shurtleff and Ms. Ferrara said they did not see water on the porch that day. And you also have...
The day of the dog's death.
Yes. And you have the defendant, and our case doesn't deteriorate because she testifies that she left water by the tree. Well, that dog is on the deck, and everyone testifies the dog loves to be out on the deck.
Wait a
And she
minute, I
claims
thought the
this-
dog was completely immobile so that the animal control officer thought the dog was
Right,
dead.
so it can't go over to the water bowl by the tree.
It also couldn't go over to a water bowl further
Anywhere.
on the deck.
Right.
Or eat food. It was, I mean, at that point, and I don't know how it got necessarily that point, the jury seems to think it was intentional failure to feed or water, although they were
Right.
instructed on shelter too. Were they instructed what date we're talking about? Or just any time while this defendant owned the dog?
When you look at Erickson, it doesn't isolate, certain, how many hours the dog had been without food. They go in the house and they find an emaciated dog and no dog food. That's enough to show that she intentionally deprived the dog of adequate food.
And
The
did
cat-
anyone find no food here?
There was no food there was testimony there was no food on the deck,
The
even
deck,
though she
but
said.
the
Well, that's what the
dog is-
dog, I mean, her story is the dog, what we have is the animal control officer arrives, the dog is on the deck, dying or is almost dead. The people that come to the scene don't see a water bowl, they don't see food. And we have animal hospital records that say it was very emaciated. It was 33 pounds. It's a husky, severe diffuse muscle wasting, and these pressure point issues, which, I would say all lead to a reasonable inference that this dog was not getting adequate food.
How probative
water,
are
or
the
shelter.
records? How probative are the records from the animal hospital? There's
I
no
think-
one there interpreting them. We can all read this thing, and you see dehydration, you see emaciated, but there's no testimony from the treating veterinarian. There's no one else. We're all, is this really how solid is this evidence to establish?
I think it's very powerful, because first of all, again, light most favorable to the Commonwealth, and secondly, those are terms that the average person understands. Emaciated, and you also have the animal control officer who says her definition of emaciated is she doesn't feel any muscle, but she also reports that the dog was a lot of bones. It looked like it had no meat on its bones. We
That
have the
doesn't
weight.
mean the defendant didn't feed the dog, even by inference. It could be an old dog that can't eat.
Well, we're looking at reasonable and possible inferences, and a
And
reasonable
I'm
and possible.
suggesting it's not a fair inference. Again, I'm going to go back to what I guess seemed like a callous question. This dog, putting aside what the defendant says, she couldn't put the dog down. The vet said it's too much money. She calls animal control. Animal control says we can't put her down. So what does she do? Maybe she feeds the dog, but the dog doesn't eat. Maybe she gives the dog water, but the dog doesn't drink. Are we criminalizing that now? What is she supposed to do?
But the theory of the Commonwealth's case was deprivation
Of adequate.
Of
That word is
adequate
adequate.
food and water.
So tell me what evidence is there that it wasn't adequate? What evidence did you prove that she didn't give adequate food?
The
and
dogs,
water?
well, there's no food she said she put a food bowl out, and the dog just could eat whenever it wants, but there's no food bowl out there. There's no water out there.
She said she put food outside or inside?
She didn't, I don't believe she specified. But then she testified also that the dog only wants to be outside, it never wants to be inside. It's an outdoor dog.
That
It's a
doesn't mean that she
coyote.
didn't feed the dog inside. I mean, I have to say, when I look at that medical report, if I had to guess, based on everything, I guess that she failed to feed the dog. But I think I might be speculating there. Now, I understand, I mean, you talked about muscle wasting. If someone said, well, muscle wasting, if a dog is dying and doesn't eat for 12 days and then dies, it might be thin, but it wouldn't be emaciated. It might be emaciated, but it wouldn't have muscle wasting. And so on, right? Someone maybe could testify to that, because it does seem that this dog is in really shocking condition. But I'm not sure, we're saying a jury can infer without someone saying to them, this pattern looks, doesn't look like dying dog not eating it, looks like starved dog dies. I'm not sure if they have been given enough, to reach that conclusion without sort of guessing.
I would just say that, again, we're looking at the standard of review, like most favorable of the Commonwealth. Could any rational finder of fact find the essential elements? I would say yes, because you can consider circumstantial evidence and reasonable inferences, and inferences need only be reasonable and possible. And it's reasonable and possible to determine, based on this evidence, you have the witnesses testifying, no food, no water.
Was there evidence? Was there evidence, or was it maybe struck? I don't remember. Was there evidence that the animal control officer had come out a bunch or something?
There was evidence that she had come out in the past as well on food concerns.
On food concerns? She never mentioned food
I
concerns.
thought she mentioned
No, she didn't mention food or water. She came out with licensing issues, which resulted in a citation, and she mentioned shelter. But I don't think she specified food or water in any of her visits. The food the water comes from the neighbor who mows the lawn, who sees the dog there for hours at a time on several visits, right? And then that's the evidence of no water and food, and then it's the day of the death.
I do have a note, Your Honor. I'd have to check my brief, but I took these notes from the brief, and I had written she had been there in the past over concern about animals not getting enough food. Okay. So I do believe that in the fact section of my brief, I would have a citation for that.
I did not see that on the record, but I would love to see that. That'd be helpful.
And that's in your brief?
It should be. I don't think I would have written that note. It would be in my facts section of the Commonwealth's case. So I would just argue that looking at the evidence in light most favorable to the Commonwealth, you had the witness's testimony, the hospital records, you have evidence of emaciated condition, muscle wasting, dehydration, hair loss over multiple pressure points, an unkempt dog, and I think with all of that evidence, we proved the general intent, which simply requires a defendant to intentionally fail to provide.
Okay, I see what you're citing now. ACO Gorviat Dill, this is in your brief at page 9, but it cites the transcript at 59. You quote her saying there were issues with proper shelter in bad weather or lack of food, or the actual very, very first time that I ever got called there, I was called by the landlord and he told me he thought the animals had been abandoned inside. So I actually tagged her, but she does say lack of food.
Okay.
Did the court have any further questions?
I see none. Thank you very much for an excellent argument.
Thank you.
We will take our mid-morning break, and when we return, we will hear the final 2 cases for this morning.
All rise. For the notice, please be seated.
Good morning, welcome back. Our next case is number 241317, Town of Hull versus Ferrara. And we will hear first from Attorney Stevens.
Good morning, Your Honor. Again, Nathaniel Stevens, Special Counsel to the Town of
Can you
Hull.
move the mic up a little? So,
Sure.
Thank you.
Good morning. Is this better?
A little.
I'll try to
No,
move
you
into
don't
it.
have to do that.
Special Counsel to the Town of Hull. And with me is Jim Lemke, Counsel to the town, former Town Council, but he will not be addressing the court today.
Mm-hmm.
This case is about whether the land court erred in ruling that the 1886 deeds in the Ferrara's chain of title did not fall within an exception to the derelict fee statute, resulting in the Ferrara's owning a 60-foot portion of the 1 mile length of Beach Avenue in Hull. This case is also about whether the Supreme Judicial Court's 1915 decision in Hobart v. Towell precluded the land court from applying the derelict fee statute in the first
Counsel,
place.
can I ask two, preliminary questions? Number one is, do we have any idea from the record what the proposed plan is for this area of land that's in dispute? Is the town planning on doing anything with it, or is it going to leave it sort of undeveloped, or?
Within the record, there's an affidavit from the resiliency officer of the town of Hull speaking to all the state grants that the town has received over the years to beef up the dune system, which crosses along Beach Avenue, in front of Beach Avenue. To do that, so the town would like to be able to have the right to maintain that because it protects not only the defendant's property, but the neighborhood behind Nantasket Avenue. It lowers an elevation, so not only are the waterfront homes at risk of flooding and sea level rise, but also the neighborhood.
So I don't understand. I mean, again, it's not quite tangential to this. If they have the fee interest, presumably the city has an easement to do that. No? If you've been doing it forever? If it's a road? I mean, I don't know what the rules are about roads, but there must be other roads in Hull, where to the middle line, it's a fee in this one and that one, but it's a paved road and it's maintained by the city. I mean, presumably the city didn't have to pay for taking that land or whatever. Doesn't the city have some rights on things that in the plan are designated roads and ways, or no?
The town maintains that it has the fee to
I
these
get
roads,
that. I'm
but-
asking what
yeah.
difference the case makes. If you don't have the fee interest, can you really not do everything you could do on any other road? Because there are roads, I'm sure, somewhere in Hull where the fee interest is in the people across the street, right?
Right, I think that was, yes, theoretically, I believe they could. I'm just not sure what the easement rights are. Perhaps the town would like to have full control, as a fee owner has, rather than just an easement holder to be able to do other things.
And if you have fee interest, well, of course I'll ask opposing counsel this, if you have the fee interest, can't they still cross this thing to get from their land to go to the beach?
Yes, they could.
And aren't there conservation regulations that will both prohibit them from whatever, building a beautiful deck or something, or house, something on this land, and that also might require them to maintain the dune exactly as you are, but they'll pay for it?
Yes, well, the issues come down to is that they would like to have their own private walkway through the dune, which the town maintains is not healthy for the dune.
Walkway through the dune.
Walkway through up and over the dune.
And we've never litigated, if you had the fee, what their easement rights would be. But mightn't they include a walkway across the dune if they've been using it that way for 120 years?
That was an issue that we didn't reach in the case because we got to.
Yeah, because the fee thing ended.
Fee thing came
How do they get from one lot to the other now? Or in the past?
They do, yes. So apparently they walk out. So that their house actually, although the address is 169 Beach Avenue, their main entrance and their garage and their driveway is on Lewis Street, which is the paved.
So your
portion.
position would be, although I don't know if this matters, that certainly they don't have like an easement by implication, although they might just have an easement or prescriptive easement. They should just walk down Lewis to get to the beach instead of some number of feet in on the dune walking across.
Yes, because the town policy is that they would like to close down all these illicit entrances, private walkways across the dune, because it's a death by 1,000 cuts rather than having
so the city has already been shutting down on other pieces of property, people cutting across the dunes?
They have been endeavoring to close down these, what they call unpermitted pathways through the dunes.
Has any of that been litigated?
I'm sorry?
Has any of that been litigated? Do we know if these people have easement rights or don't have easement rights?
I'm not aware that specifically have been litigated.
I'm sorry, and I think a lot of this
We
is
may
outside the record.
Yeah,
but
we
when
may
you-
take more than 15 minutes because we're all very interested in this
Sure,
case.
thank you.
so-
No, it's an important topic, thank you.
When you say pathways,
Pathways.
does that mean just walking across the dune, or they want to build something like a walkway, whether it be wood, concrete? Define what you mean by pathway.
Sure, pathway, so approximately foot or so wide that goes through up the, it's the sand, currently sand, I believe, goes
Okay.
up over the dune, over the grass, down the side to Nantasket Beach.
Okay.
The issue came to head when they applied to the Conservation Commission for a permit under the Wetlands Protection Act to maintain that pathway and, improve it. I think put down, if I recall correctly, put down some more supportive
Okay.
surface and things like that, and the issue came to head.
I'm not sure I understand what you mean, more supportive surface. Do you mean they'd pour concrete? Do
No,
you mean
not-
they'd make a wooden walkway?
A mat, it's a type of mat that lies on the sand that's somewhat flexible.
And is
provides a
that
little bit
permitted
more
in, I don't know what the zoning rules are about dunes. Is that permitted? Even if they own it, are they allowed to put anything on a dune?
It's more of a conservation issue than a zoning issue, Your Honor. It's by the Massachusetts.
Can they build
Wetlands
on,
Protection
well,
Act.
I'll ask your opposing counsel too, if they now own this, can they build on it?
No, because I believe the zoning district does not extend onto Beach Avenue for single-family residents.
You think that they couldn't, even to the halfway point of this thing, put something, we just said, although I dissented, we just said that some family could build a bocce court on their right-of-way. Seems wrong to me, but again, we said it, and so that's the law. Could they build a bocce court halfway out?
If they own the fee and it wasn't interfering with other easement
Notwithstanding the zoning, what you've said about zoning on Beach Ave.
Right, no, there's no, my understanding is that the zoning district that would allow construction of a structure, a house, residence, does not extend over Beach Avenue.
People who own a fee interest somewhere in Hull, over the road in front of their house, and you agree with me, there must be some, right?
Must be some, yes.
Must be some.
Can
they build a bocce court out to the yellow line?
I would think not.
Why?
It would be interfering with the roadway.
This is a paper street. I'm not advocating paving over the dunes. I'm sure there's a state law that wouldn't let you do that. But if it weren't dunes, you could pave it, right? Can't you pave a paper street? I mean, it's designated street on the plan.
Sure, I think so.
So if you decide to do that, then they couldn't build a bocce court, right? Because there'd be a road there. I'll also ask opposing.
Well, can I ask
counsel.
one more basic
Yeah,
question?
sure.
What can people do with their beach lots?
I'm sorry?
What can you do with a beach lot? What can the Ferraras now do with their beach lot? Can they build on that? Can they develop that? What is that?
No, again, the zoning district does not extend out that far to allow building of structures. Also, the restrictions in the deeds do not permit any structures being built there. And
So
again,
it's just
as a matter of
beach
conservation.
that they own, but you can't otherwise exploit the property or build
The
on
Beach
it.
Avenue,
The
correct.
The beach lot,
The
right.
beach lot,
You can't
yes.
on the house lot, and then if there's the part in between that we're fighting about, the disputed area, it's a question as to what you can do in terms of developing that.
Correct.
But if it all were together, wouldn't it merge? If they owned all three, wouldn't it merge, and mightn't the buildable part of their buildable lot now extend further? I mean, I hear what you're saying about zoning. I don't know how zoning ends at partway through someone's property. Maybe it does. Is that the line that's shown? It's at on the
I believe the zoning map has the line
landward
there.
side of.
I haven't looked at the zoning map in a while, as zoning wasn't a prominent issue in this case. I think it's the conservation issues that are going to more dictate what can and can be built, frankly, than the zoning. Even if the zoning did permit
And the
it, I
beach
don't
lot,
think it could be
is it
permitted.
open to the public? The Nantasket Beach is open to the public, isn't it?
Correct.
So even though this is a privately owned beach lot, they can't exclude anybody. Or at least from the end of the dune down to the water or some.
Right, yes, and there is language also in the deeds to the beach lots that do say that it needs to remain open to the public.
And if
accessible.
they owned the disputed area and they built this pathway, could everyone use it?
I suppose they could use it up to the beginning of Beach Avenue, to the oceanside
So you don't
Beach
think the
Avenue.
public has an easement to this Beach Avenue, which is just sand, I gather?
It's mostly sand, yes, some beach grass, and I think some plover
And you don't think the
bird
public?
habitat. And some bird habitat as well.
Do you think the public has an easement to cross it? It's been that way for 122 years. I don't know if anyone does walk on that.
Yes, I would think they would have an easement by prescription, but also, again, there's language in the deeds, and also furthermore, part of the beach lot, I believe, extends below the.
No, but I'm asking about the disputed area. I suppose the lower half of it would be part of the beach lot, would be, conveyed with that deed with whatever the restrictions are, and then the other half would belong to the.
To the long
other
house
lot.
lot?
Yes, although I don't know what would happen in terms of merger, but again, I'll ask your brother. But
So
maybe
now
we
we'll
should turn
get
to the
into your-
legal.
Now we'll get into your argument.
Yeah.
So I don't know what order you were going to have, but let's start with the order I want to start with, which is, you say that the fee doesn't fit into the derelict fee statute, okay?
Correct.
Why?
For a number of reasons. We feel that it's it falls within the exception to the derelict fee statute. The second exception, which provides that if it's an instrument that evidences a different intent by express reservation or exception, and not alone by the sideline. The language here that we point to is and this is from the 1886 house lot deeds, and also the 1886 beach lot deed. And this says, and the said grantors specially reserve to themselves or their successors the right to change, lay out anew, or discontinue any street shown on said plan not necessary for convenient ingress and egress to and from the granted premises.
What does that mean? The right to, what are the first two? They can move the street?
The right to change,
Okay.
lay out anew, and yes, change, is it change the direction of the
So
street?
someone buys the
Change number
lot,
of-
they're thinking, I'll build a house here, and the grantors say like, gotcha, we moved the street, it goes through your house lot now. We thought instead of going straight, it would curve through your house lot.
Curve around.
They can do that?
Seems to,
That seems
lay out
like a
anew.
very odd reservation.
It could be referring to the fact that even if it's the right-of-way is, the street is 50 feet wide, commonly you have a used portion, paved portion, dirt portion is narrower than that 50 feet. So perhaps it's referring to just, okay, we're going to put the gravel portion, the supported portion on the east side rather than on the west side of that 50
But if it were a fee interest, then the grantor could do anything with it. This is clearly going to go over.
Can I step back before we get to the exception and just help me understand, because I find this very, very difficult.
Sure.
The statute says every instrument passing title to real estate abutting away, whether public or private, right? What's the instrument we're talking about here?
The instrument here is the 1886 deed from the.
Why is it the 1886 deed, not the conveyance to the Ferraras in 2006? That's the deed that's at issue. Why are we talking about the 1886 one? Why aren't we talking about the deed that exists now?
Because it's the title goes back to the chain of title goes back to this, excuse me, this is where the split is between the developer conveying off the lots versus the split to conveying the streets to the town. So we've gone back to that.
See, in the second part is construed to incur any fee interest of the grantor. So we have to figure out, is there a fee interest in the grantor in the way? And as I understand your argument is, there was the original Norwell deeds in 1886, and then 1887, the Nantasket Company sold the way to somebody else, right?
Jordan.
And then that was eventually sold to the town of Hull. Right,
1913.
So
yep.
by the time we fast forward to 2006, when it's the trustees of the Townsend Living Trust, there is no grantor fee interest in the way. It's already been sold. And the decision of the judge below is that, well, no, we're going to go back in time and nullify all these earlier transactions to say those transactions didn't happen. The fee interest in the way was never conveyed to another party than to the town of Hull. Do you think that's right, or you disagree with that analysis, that we can go back and undo transactions as to the conveyance of the way?
Right. No, we disagree. I mean, we agree that we should not undo what was conveyed, what's evident in the 1887 deed to the
Leave
one
Hobart
Jordan
out
in
of it.
1913.
Leave Hobart out of it. Let's not talk about Hobart yet.
Okay.
Do you still agree that you can't undo this 1887 deed to Jordan?
Yeah, I would agree you can't undo it if it's, as long as it's not conveying the street interest.
But isn't that what
It is,
Isn't-
the whole deed, eventually the deed to the town of Hull is all the streets in Nantasket.
Nantasket, right.
But
So,
isn't
right.
that what the derelict fee statute allows for? It says it's retroactive unless one of the exception applies. So you can undo, quote
And you
unquote.
flip, right.
So you agree that the statute permits that unless there's an exception.
Wait a minute, so let me ask you that. It's retroactive, which means it applies to deeds that existed before 1972. It's not a time machine. It doesn't go back in time and reverse conveyances that occurred. Isn't that the distinction here? Retroactivity means, okay, we're going to apply to existing deeds. It doesn't mean we're going to go back in time and say this conveyance that occurred in 1887 and subsequently was given to transferred to town of Hull doesn't exist anymore. We're going to nullify that. Isn't that a fundamental difference between retroactivity and nullifying prior transactions, prior conveyances?
If I follow, I would agree, yeah.
Okay.
I mean, there'd be a taking problem, maybe not in your case because you're a town, but if someone else had bought this road and, whatever, had their hot dog stand on it or whatever, and had had it for 120 years, and suddenly in 1970-something, a statute passes that says that's not yours anymore, presumably, and there is no court decision that they're relying on, they're just relying on that their predecessor in interest or even themselves, they bought it in 1887, it would be, I would think it would be a taking, wouldn't it?
Right, and that's one of we believe this is one of the only first cases dealing with the municipality with the derelict fee statute. Many of the cases are involving private parties, so.
Are there other cases that nullify grants subsequent to application of the derelict fee statute? That hold, there was nothing to convey because under the derelict fee, and someone did try to convey it, for example, to a railroad or to whoever one gives roads to.
Right.
And we say, no, they had nothing to give.
I don't think I don't recall the case law using the words nullify. They just say, now reading the deed, the fee, the fee was actually not with the grantor,
But the judge
but to
here
the
says,
grantee.
It's a nullity. He says specifically, yes, you would have interpreted previously prior to 1972, but now those transactions are a nullity. That's what he's doing here. He's undoing transactions.
Right.
But that's why I get back to the question of what are we applying the statute to? Because if there's no, when the Ferraras bought the land from the Francine Townsend Living Trust, they didn't have a fee interest in the way because the way had already been conveyed to the town of Hull. So what's at issue here? That's what I find this case so difficult to understand. It seems like you go back and talk about the 1886 deed, but that's been changed by events. And I just don't know what fee interest is left that the Townsend Trust or anyone else could have conveyed or not conveyed to the fee interest in the way.
Right. Well, I agree. I think that the land court judge here said that they did have a fee interest to convey down for the house lot and for the beach lot.
Do you agree with that?
So, no.
Okay, thank you.
Can I ask you then, I guess, I need to know what you think the definition of nullity means as opposed to that it's retroactive. Because I read the judge's decision of saying, yeah, at one point there was a conveyance of a fee, but under the derelict fee statute, I'm saying that wasn't really a fee that was transferred.
Right.
In essence, saying it's a nullity because the statute says it's retroactive. I go back in time and I look at it and say, that was not actually a fee that was given. So what is your definition of nullity versus retroactivity? What does retroactive mean in the statute if the judge got it wrong?
Right. Yeah, I think nullity is just nothing is conveyed in the deed, right? I mean, the deed is just gone as if it doesn't exist.
At least the fee, the transference of the fee is a nullity.
Fee, right.
Okay, so we agree that that's what nullity means.
Nullity,
so what does the statute, if you're saying that's wrong, the judge used that word wrong, tell me what retroactivity means in the statute if that's not what it is. It has to have some meaning.
Right.
If it's not go back in time and say, I am applying this retroactive, what does it mean? Again, putting Hobart aside, I know you say there's an exception. I'm just trying to figure out if we don't agree with your argument that Hobart takes it out of the statute, do you agree then that the statute should apply?
No, well, no, we don't agree it should apply because we feel that this is not the situation for which the purpose of the statute was created to resolve derelict fees. Again, there's no derelict fee. It's not but
that's not, I don't know if there is or there isn't, right? The question is, in the 86 deed, did they in fact convey or not? Now, we know from Hobart, I guess, that everyone thought they had not conveyed the fee interest, but the derelict fee statute seems to say we can't look at that anymore. We just look at the thing, and you say this reserves a fee interest, but the right to move the roads isn't the way I'd describe a fee interest, right? I'd say, but we retain the road, or, something like that. I also don't understand, it seems as though the various buyers of the beach lot from 1886 or 1887 really, until I don't know when the Ferraras first said, this is ours, maybe in response to your lawsuit. But why don't you argue that they rested on their rights for too long? It's 150 years ago or something, right? Can people just come in and say, like, I know we all thought this, but I dug something up, and it turns out that the grant of the streets was the year after the grant of the beach lots, and so undo 150 years of what everyone thought. Isn't there some argument for, I don't know if it's laches or estoppel, or I don't know if this is an equitable matter or a law matter, but why you don't argue that?
No, we were wrestling with the derelict fee statute.
Sure, but why? Why are you arguing about something that happened in 1886? Why are we changing? I mean, presumably, and I don't know, I'll ask again opposing counsel, presumably everyone thought this belonged to the town. And now suddenly, someone's saying, oh no, I know, and I'll ask your brother, I know Manamet Road belongs to the town, but not this one. And they don't even say not Beach Ave, they just say the disputed area. I'm not sure why you agree that the fight is about the disputed area instead of about all the roads in Hull and Nantasket, since they're all conveyed by the same 1887 deed.
Right. Well, I think it's the context and how this case came up, which was the filing of an application with the Conservation Commission for a permit to maintain this pathway under the Wetlands Protection Act, in which case you require the signature.
And did the application indicate who the owner of this lot was?
Well,
Or they wanted the pathway?
The Ferraras asserted that they owned that lot, and
That's the first time that's how this arose, an assertion by the Ferraras in what year?
2016 or thereabouts.
And tell me why or whether this acceptance of the deed by the town in 1991 matters.
I think just reaffirming their ownership.
Reaffirming. But you think they owned it even without accepting it?
I think there is, and again, this is not in the record as far as I can recall, as to why it was why that vote took place in 1991. Perhaps someone at the time couldn't find the records of the town meeting vote closer to the time.
The deed asserts that it was for $1 and other valuable consideration, right? It suggests that this isn't, well, I don't know, it's a result of a bequest, I guess, but it suggests that you bought the land from the trustees of the estate of Jordan.
Correct. And I think town records are spotty for that era.
I'm sure, but you have a deed in the registry of deeds, it says.
Right. Yes, no, I'm sorry. In terms of why town meeting voted again, I think the town records were not there when someone was looking in the 1990s, did not see the town records.
Judge D'Angelo has some questions.
Before I get to Hobart, which I do want to talk about, I'm a simple guy. I presume that the Ferraras have been paying taxes. Did they pay taxes on the disputed area as if they owned the fee?
And
Did the town say, wait a second, you don't have to pay that because we own that? Was that ever an issue in this case?
No, Your Honor. That was not an issue. And
That's been brought up. Okay.
Wait, the tax records of this have never been referred to?
They're not in the record.
Okay, see, simple minds sometimes come up with simple answers. Anyway.
Oh, no, but that's actually, I'm shocked by that.
By either side.
By someone who wants this fee should be saying either, we've been paying the taxes forever, or no one's paid taxes. And we literally don't know that.
I'm trying to recall if there's a tax map in the record which would show whether that lot includes.
You didn't think that was an important thing to put in? Or maybe it's because they paid taxes, but.
Yeah, no.
Vice versa.
You'd think they'd have
We'll be asking him as well.
Outside of the record, my understanding is that they have not been paying taxes on that.
Isn't
or on
acceptance of a deed one of the ways that maybe the only way, that you move something off of tax rolls because you've accepted a deed to it and it shouldn't be taxed anymore? Isn't that what accepted? I don't know under what statute or for what reason you accepted it, but there is a statute that says if you get a bequest or a gift or whatever, not that this was those, right, the town can accept it and then take it off the tax roll, presumably because gifts sometime, although this was paid for, allegedly or assertedly, gifts sometimes are, oh, it's my nuclear waste lot. I give it to the city of Hull, and they're like, slow down, buddy. Like, we don't want that. But if you do want it, then you can accept it and take it off the tax rolls. But you don't know if that happened in 1991.
No, I don't know if that happened.
What year did the Ferraras buy the property?
2017, I believe, or thereabouts.
Okay, let's get to Hobart now. In your brief, you say the judge ignored the Hobart finding that the town had been conveyed all the streets shown on the Nantasket Company plan from the 1913 deed. I'd love to know where you got that in the Hobart case, because when I read it, it references Manomet Avenue in the decision. Now, there might be some dicta, but the actual decision only is talking about Manomet Avenue. So where do you come up with the argument that it was all the streets?
Excuse me, I'll try to find that language.
Because the exception under the derelict fee statute is only if it's an actual case that applies to that property, which certainly only makes sense. So I'd love to know why we think this property was part of Hobart at all.
I'll have to get back to you on that. I can't locate it right now.
Well, isn't Manomet Avenue conveyed in the same 1887 deed as all the other streets? It's a single deed from the trustees of the estate of Jordan to the town of Hull. Isn't it all the streets in Nantasket,
Yes,
Manomet and Beach Ave?
Yes.
All right, so if a court says, yeah, Manomet Ave didn't, in that deed, Manomet Ave doesn't go with the properties on either side of the street, that's a conveyance of a fee interest to the town.
Right.
Now we have a construction of the deed. The grant of lots reserves to the grantor the fee interest, and so they're able to convey it in the 1887 deed. And now we're looking at the 1887 deed, and someone says, not this road, but you wind up with a checkerboard that way.
Correct. And then we also, of course, have issues of there are several recorded registered properties along Beach Avenue that were registered prior to the derelict fee statute, which don't include the fee to.
How do you know they don't include the fee? Oh, because it would say.
It was, yes, it decrees what is being registered, and that does not include Beach Avenue. There are.
So if this is upheld, you own some of the streets. I guess you'll have to go through and figure out which ones they are, and not even whole blocks. A piece by piece by piece based on property.
Yeah.
And the owners of some of the houses own some of them too. Okay.
Almost set.
Thank you for taking the extra time. It's a really interesting case to us.
Thank you for your
excellent
interest.
argument.
Thank you.
And we will hear now from Attorney Brodsky, who I know is excited to join the fray.
Members of the panel, may it please the court, my name is Adam Brodsky, and I represent John and Kathleen Ferrara, the defendants, and appellees in this matter. And the Ferraras request that this court affirm the trial court's judgment confirming that they hold the fee simple title in the disputed area, which is that undeveloped portion of what we also call Beach Avenue between their house lot and their beach lot. And it's the Ferrara's position that none of the town's arguments to avoid application of the derelict fee statute are persuasive here. Both the house lot and the beach lot are recorded land. They are not registered land, and the derelict fee statute applies retroactively in this instance. And as I mentioned, specifically with respect to the statute's exceptions, none apply.
Can I ask you, going back to the very beginning of the argument, it was so long ago many of us don't remember, what difference does this all make? If the Ferraras have an easement, they have a property here, they have a property here, we have the disputed area, easement by prescription, what difference does all this make of who actually owns the fee?
The Ferraras would have to prove in the land court that they would have a prescriptive easement to travel over the disputed area, requiring that they file a lawsuit. Because the town has
Unless you get the town's agreement that to avoid all of this.
Your Honor, there have been extensive settlement discussions, which I will not discuss here, that resolve this. But I just want to, since we're outside the record, what caused this dispute was the Ferrara's desire to continue to use their beach path that has existed for more than 100 years, that travels from their house over the disputed area, over the elevated coastal dune onto their beach. And in fact, the town, and as Attorney Stevens is undergoing a dune restoration project, actually that relates to other portions of Beach Avenue where there is no dune. This is the healthiest dune that protects the houses behind it, but there are areas.
It is right now.
I'm sorry, Your Honor?
It is right now, maybe. But the question, I mean, the future, we're talking about what happens in the future to this.
Again, Your Honor, way beyond the record, the existing coastal dune is higher, I believe, than the proposed coastal dune that's going to be erected in other areas of Beach Avenue where there is no coastal dune, where you have coastal storm events going over the beach, going right onto the properties on the west side of Beach Avenue.
Why isn't it too late? You and
Yes, Your Honor.
you're the Ferraras, of course, what year did they buy this property?
2017.
Okay, so in 2017, they buy the property. Their predecessors in interest never said the 1887 deed is a nullity, and their predecessors didn't, and their predecessors didn't, and their predecessors didn't, and it's 150 years. What about latches or estoppel? What about resting on your rights for 150 years?
So I can't speak to the court regarding what anyone other than the Townsends and the Ferraras may have thought about this issue. But I think there's a bit of misunderstanding. The Ferraras could have only gotten whatever title the Townsends had.
Of course.
And the Townsends could only receive title from their predecessors in interest. What's important to remember is in the deed from Nantasket Company to Norwell, it's silent as to the conveyance of the fee interest. And even under the common law rule that would have been applicable at the time, the fee interest in that way would have gone with the deed to Norwell. So before you even get to the deed out. Yes, Your Honor.
Well, wait a minute. So, okay, let's set that aside. But in 1887, there is the Jordan deed, right, that conveys the fee in the way.
No,
right?
Your Honor.
No?
With all due respect, because under the common law rule, the fee in the way was conveyed out to Norwell, the Nantasket Company couldn't have conveyed it to Jordan.
So you're saying that the Jordan deed was invalid as of 1887. You're not relying on the derelict fee statute in 1972. You're saying it was never a valid conveyance of. Is that your position? Because that's not what the judge held.
No, Your Honor.
Judge is saying that
it was a valid conveyance. That conveyance did not include this slot, which is lot 1243 on the 1885 subdivision plan, and the fee in this portion of Beach Avenue. It's already out of the chain of title.
Okay, but it says, I've looked at that deed. I wish someone had typed up all of the deeds so that I didn't have to, but I have looked at that deed. My recollection is that deed conveys whatever we have, this and this and this, and whatever we have in Nantasket to you, Jordan, right? It doesn't delineate streets. It says whatever we have.
I believe you're correct, Your Honor. But
And then in 1895, I gather Jordan dies. No one has put anything in the record about that or why it took 18 years for the estate to sell the roads to the town of Hull for $1 and other valuable consideration. But in 1913, the estate of Jordan, at least, clearly thought it had the roads. Could have been totally mistaken because they weren't given it by Norwell, I guess. But they thought they had it, right? And they conveyed the roads, all the roads. Let me ask you this. Who owns Manomet Avenue?
I believe the holding in the Hobart case confirmed that at least that case.
It may not be all of Manomet Avenue, I understand.
But it's important, Your Honor, that case was a registration case that concerned some undeveloped land that someone was claiming was an open square. In fact, the court in Hobart said, no, that's an extension of Manomet Avenue, which had, by the time the case had been decided, had been fully developed as a public way.
But had been conveyed in the Jordan Estate deed in 1913, 2 years before Hobart, had been conveyed to the city.
Correct, Your
And
Honor.
it's described that way in the
Yes, Your Honor.
decision. Does the city still own that part?
I presume so.
Because there's a decision in Hobart of the SJC saying they own it. It would be very hard to argue that they don't, right?
Correct, Your Honor.
All right, now, that's a construction of that 1913 deed. Or maybe it's construction even of the Norwell to Jordan deed, saying what was conveyed there included the fee interest in all the streets. And so when the streets were conveyed to the town of Hull got them. And so they're saying that deed has been construed. It says the town owns the streets that were conveyed. I understand it's only about a tiny piece of Manamet Avenue, but necessarily that's a construction of the deeds. Aren't you asking us to construe the same deed to convey one road to the town, that part of Manamet Avenue, and one part of another road not to have conveyed the fee interest? And how can we do that? If the deed has been construed so it conveys fee interests, then it does, and if it hasn't, I understand it's a different property. I'm not even talking about res judicata exactly or something like that. Obviously, this road hasn't been talked about, but how can we construe one deed with no differentiation in language, giving all the streets to Hull, to say, oh yeah, that part of Manamet Avenue it did, but this part of Beach Ave it didn't?
Your Honor, again, what's critical to remember is that Jordan didn't get this portion of Beach Avenue or
Hobart thought they did. Hobart thought he got all the roads and conveyed them to the city because there's no basis to distinguish Manamet Road in the deeds from Beach Ave all the way to the end, not just to Lewis, but to A Street.
Your Honor, the 1913 deed from Hobart to the town says, I'm going to give you whatever I own. All of my interest in, the state of Jordan said, we're going to give you whatever we own now.
I read it. It gives Beach Ave from A to wherever. I don't know if it's by meets and bounds reference to the plan. It is not a whatever we have deed. It lists each road and a 47th parcel and a 56th parcel and right down.
Your Honor, and not my client's parcel or this portion of Beach Avenue, and that's the distinction, because the estate of Jordan couldn't grant that to the town because these properties had already been conveyed out to Norwell in a separate...
Just like the properties over at Manamet Ave.
Different chain of title, Your Honor. And again, no dispute with respect. Manamet Avenue was constructed as a public way, accepted...
That doesn't give you a fee interest in it. Right, there are public ways that are privately owned.
That is correct.
Okay.
That is correct, Your Honor. Again, I'm not here to contest whether the town has title in Manamet Avenue. I'm here to contest whether the town has title in...
Yes, my question is, why don't you have to contest that? If you hope to have this deed read under the derelict fee statute rather than under the construction in Hobart, now you say it doesn't give Beach Avenue all the way across. That's not how I read it. If it's not in the 1913 deed, then we're not undoing any grant. They never got it, but I didn't read that to be your argument. Right? You don't say that you say it's a nullity, not that it didn't purport to convey.
It wasn't, I'm not suggesting it's a nullity, Your Honor. I'm saying that the deed from Jordan and the Jordan estate to the town did not include these properties because they had been previously conveyed out to Norwell.
Just like the ones on Manamet Avenue had been previously conveyed, they had not been previously conveyed.
No, Your Honor, because they're two separate transactions. We have the 1886 transaction from Nantasket Company to Norwell, which is our chain of title, and then after that, you have the conveyance from Nantasket to Jordan of other portions of Hull. So our title...
And wait. And those other portions of Hull, it's from Norwell, so it's still in the same deed, right? Your deed gave the lots to Norwell, and it's Norwell who gives whatever's left to Jordan, right?
Norwell to Jordan.
Oh, you're saying it's the trustees who give it to...
Correct, Your Honor. It's not Norwell. So it's actually the Nantasket Company conveys out our properties to Norwell, and then you run that chain of title.
Okay, and what year what year were the lots? Oh, the lots were given to Jordan, the ones on Manomet Road.
That's correct. The date of the deed to Jordan, I think it's 1887, Your Honor.
Can I just...
1887, Nantasket Company to Jordan. And again, Your Honor, coming back to originally, the problem is that the original deed out from Nantasket Company to Norwell doesn't expressly include the fee.
Does the one to Jordan does?
I don't know, Your Honor. It doesn't matter.
It does matter because the question of what the 1913 deed means is what's
Your Honor, I'd have to review the deed because they typically describe the lots by the sidelines of the ways. That's how it's typically done. And under the common law, again, under the common law, the fee in the way would actually be conveyed with the lots to the center line. The only difference is under the common law, you can challenge that presumption with extrinsic evidence. You can look to the grantor's intent. What did the Nantasket Company intend?
Okay, we got it. So, but this is, I think, a really critical issue that Justice Rubin is raising. And just assume for a moment that the disputed area was conveyed to the town in 1913. Just assume that. You lose, right?
Yes.
Because there is no fee interest in the way that can be granted by the time the Townsends relay the property to your clients, right? So if there is a transfer of the disputed area to the town to 1913, then the derelict fee statute doesn't kick in. There's nothing to be kind of figured out in modern times, right? So this really is
yes, Your Honor. If the 1913 deed expressly stated that the fee interest in the disputed area was conveyed to the town, we wouldn't be here.
Because it seems like that the judge is saying it was conveyed, but now it's a nullity because I'm going to apply the derelict fee statute to undo those transactions. Am I misinterpreting what the judge did?
I disagree respectfully, Your Honor. All that the judge did is retroactively apply the derelict fee statute, which then prohibits...
To what? What did he retroactively apply to? To what?
To the Nantasket to Norwell deed, which is where the title comes.
But that's undoing all these series of events that follow.
We're not
from
undoing
that.
anything.
It only applies to the deed at issue, which is the deed that you're from the Townsends to the Ferraras, right? That's the only thing at issue.
Your Honor, we're not undoing anything because, again, by application of the derelict fee statute, all of the property owners in the chain of title would have received the fee interest.
Where in your brief would I look for the argument that it's a different chain of title that leads to the Manomet decision?
It's
Hobart?
right in the statement of facts, Your Honor. Again, we've made, and I can point it to, we made the argument right from the beginning, Your Honor, that, excuse me, that the transaction from the Nantasket Company to Norwell included our lots, and that the subsequent conveyance of Nantasket to Jordan did not include it.
I'm asking about the Manomet Road case. Their argument from the beginning has been, Hobart, right? So you have to, now you might just say, well, it's two different lots.
Well,
but do you also say the way they were conveyed to Jordan, such that they were in the estate, is in a different chain of title?
It is, Your Honor. It's in the Jordan chain of title, not in the Norwell chain of title, which is why on the facts.
But I thought I see. So there's a Jordan chain. So we need to look at the deed. I need to look at the deed, it seems to me, from Norwell from the Nantasket to Jordan.
To Norwell, and all of the deeds in that chain of title are in the administrative record.
Okay, great.
What you're going to find is the same thing, that they convey the property by the side of the way.
And the exact same language about reserving the right to move the streets or whatever that is.
Yes, it comes and go. And I'm happy to talk about that because, as you know, under the derelict fee statute, which is applicable, you can no longer consider an extrinsic evidence. Not that I think that there's any extrinsic evidence here that the Nantasket company intended any differently, but that restriction is not an express conveyance of the fee. And the restriction was to allow the Nantasket company, which, again, when it conveyed out to Norwell, it owned other large portions of Hull, and it wanted the ability for those reserved portions of land that were not conveyed out to be able to lay out roads and readjust the roads. What's importantly is that it didn't convey a fee interest, and that's why the derelict fee statute is important here. Again, I don't even think that restriction is evidence of the Nantasket company's intent to convey the fee. It's simply a land use restriction, and the case law is clear. I mean, easement rights, the use of land, that's not a clear conveyance of the fee. There has to be a statement, I grant the fee in this way to X.
If Hobart applies to the disputed area, do you lose? I'm not saying it does, but if we find that we conclude that the judge was wrong.
So just to be clear, Your Honor, are you asking me under the common law interpretation of deeds whether we win or lose? Is that your question?
I'm asking under the common law and under the derelict fee statute.
Yes, Your Honor. I think we get to the same place because I don't think, if you're going to apply the common law rule, which was applied in Hobart, and consider extrinsic evidence, the only evidence that you have before you is this restriction. I don't think that restriction can be reasonably interpreted to convey an interest in the way. That's a reservation of the Nantasket company, again, relating to the lands that they still own, that they've got the ability to put a road here. Maybe they want to connect it to Manamet Avenue.
Here's my problem with that. The judge didn't even get to that issue. So
Correct.
What do we do with that? You didn't appeal the judge's decision, correct? Just want to make sure.
That's correct. Because
so the judge's decision was the derelict fee statute applies, and I'm paraphrasing, because Hobart doesn't apply. Hobart's not an exception. So if we conclude that Hobart does apply, it seems to me you lose, because we don't look at the common law part because the judge didn't make that conclusion.
This court would have to find what the grantor intended, because I guess so our position is the legislature in its infinite wisdom granted the derelict fee statute.
I don't know about that, but keep going.
And have you met the legislature?
Sorry, we digress. Wrong brain.
Yes, no, I appreciate that.
Well, we get to read the coherence of what they write, so we have
As a mere lawyer, I'm required to comply, or at least do my best to comply.
That is fair.
To comply with the statute, and I'm going to digress. There's good reason why they did that, because there was a lot of mischief going on with title to ways. I think this case falls into that category, candidly, because my clients have and their predecessors has for decades exclusively used this area. The public doesn't trespass onto this land. There's a beach path from the Ferrara's beach.
Well, these are fact questions that haven't been resolved. I don't know who
Your
uses
Honor,
this land.
I admit it, we have been talking off the administrative record for some time. But this is the kind, so the town goes to the Ferraras, hey, listen, just permit the beach path, right? We'll make it kosher, we'll make it legal. And lo and behold, they submit a notice of intent in 2020. And I mean, I'm choosing my words wisely, I'm at the appeals court. Anyway, by unanimous vote, without even much consideration, the Conservation Commission denied that. That's on appeal. There's a superseding order by DEP that actually approves that project, that the town has appealed, and that administrative appeal has been stayed pending this case. But the town...
Does it matter who owns the fee for that?
Yes, because the town said, oh, we own the fee in the way, you're not the landowner, you have no legal right to file a notice of intent. That's the kind of mischief that I think the derelict fee statute
someone might-
is intended.
The question of whose mischief is whose is sort of what this is all about. Let me just say this. I'm looking at Hobart versus Towel, and it says, the respondent derives title by deed from Norwell, not some other way. I assume deed from Norwell is that same deed from which?
I do not know, Your Honor.
All right, well,
So I'd
these are
have to
public
review the
records.
records.
We can figure
Yes.
that out. There's nothing else?
I feel like we've covered it.
Do you feel like we covered it?
Very well argued.
Good.
Very well. All right. I see no further questions, although he had much more time than this. If you have anything to add, or you feel like we've...
Your Honor, I think we've covered all of the critical bases, and I'm happy to rely upon our brief for some of the
All right.
extraneous arguments.
Excellent, excellent argument by both sides. Thank you very, very much.
Thank you, Your Honor.
The case is submitted. The next matter is an impounded matter, so I remind the attorneys to use pseudonyms for parties' names, and if there is other impounded material, you will be more aware of the scope of the impoundment order perhaps than we. Obviously, nothing impounded should be referred to in open court. It is number 24-1439, Department of Children, Families, and Others versus Father. And we will hear first, well, I'll let you get situated. We will hear first from Attorney Como.
Good afternoon, Your Honors. Attorney William Como, representing the appellant father. May it please the court. Your Honors, up until the removal in September of 2022, the family had appropriate housing and a family shelter. The father was employed. He was agreeable to accepting services from the Department of Children and Families and their collaterals. He had a working relationship with his providers, and he was observed by many to have taken very good care of his children, especially the youngest child. At the removal, the children were still being provided good care. The issue, as best I could glean from this record, was that the oldest child had left the home, had gone somewhere, father did not know where, and they were concerned that she was, at 11 years old, sexually active. The father had had issues with his daughter in the past, but it all related to his ability, or her willingness, I suppose, to comply with his request that she do some chores around the house. That was the extent of it. That was the basis for the removal. Now, I'm not here today to argue a moot issue, which was that the court never should have removed the child in the first place.
Yeah, that's my question. So, because you seem to be arguing that in your brief, so and you don't seem to be challenging the determination of the father's fitness or the termination of his parental rights. So, I'm trying to understand what exactly are you advancing to us?
I am pointing out that at the time of the removal, father was an appropriate caretaker for his children, regardless of the actions of the juvenile court. The children weren't in immediate danger of serious abuse and neglect.
I don't know what happened that night, but of course he had exposed them repeatedly and not that long ago to domestic violence in the home against the mother at least.
The last incident, as I saw from the record, was approximately a year before the removal.
The pushing out of the car?
That was unsupported, Your Honor. There was a 51A for that allegation, but there was no support for it. It was unsupported by the Department of Children and Families. And so, generally speaking, a 51A is not evidence of something. It's a basis for instituting services, but it's not
evidence before. Is there not evidence before the court in the form of hearsay statements of the children about it?
Well, hearsay statements of the children, they weren't objected to. So yes, but I don't believe that there was a hearsay statement other than in the 51A that it was something that was established in the record. The court in his findings, the judge in his findings specifically said in a footnote that 51As were not admissible.
No, of course, 51As are not admissible. I thought in this record there was other evidence of that than the 51As. I may be mistaken.
And I may make a mistake as well,
Okay.
Your Honor. I don't
So you're
have
saying
that.
a year ago was when he smashed her face against the wall?
Judge, I am not.
Picked her up by the throat, I think, and did that in front
That
of the
is the
children.
allegation, yes, Your Honor.
So I don't know what kind of care, you say he's an appropriate caretaker.
Well,
But the DCF may not have acted adequately promptly, or maybe, I don't know. But it's not a rosy picture.
It is not. It is not, absolutely. My client has mental health issues. My client has apparently anger issues. My client had difficulty working with the Department of Children and Families. That's in the record. I'm not going to sugarcoat that. But what my argument is that even with those actions, the department did not remove these children. And the department offered services. Father was willing to accept services, and at the time of removal, had filed a CRA in order to get his daughter services. He had had a willingness to accept services from the department. He wanted his daughter placed at St. Vincent's, and lo and behold, after DCF got custody, where did they place this young lady? At St. Vincent's. And so my argument is basically, Your Honors, given this record, that he was doing what he could with the services that he was offered.
Well, counsel, I understand it's a difficult case, but the plan from DCF included numerous things: mental health treatment, counseling, parenting class, take his medications. The record indicates that he refused to take his medicines. He missed therapy sessions with the neuropsychological evaluation. He was discharged from the parenting class. He missed visits with the children. He exhibited numerous behaviors that were concerning. When you say he was compliant, I guess I don't know what you mean based on that record.
Well, I did not say that he was compliant with the current action plan. What I was saying was when the children were removed, he was sufficiently parenting. Not at a level where he was going to win any sort of awards, but certainly at a level where he met the minimum level of parenting.
Even if I agreed with you on that,
Yes.
his subsequent actions, and again, I know the DCF plan isn't the Ten Commandments here.
Yes, Judge.
But he didn't comply with them.
Well,
Can't a judge rely on that to show that he will not be a successful parent?
that is some evidence of unfitness, absolutely. I would argue, though, that when he did complete a parenting class, I think you were referring to the domestic violence program that they asked him to participate in.
I thought he failed to attend the classes consistently. I thought that was, I could be wrong.
Yeah,
It's memory.
my recollection, and you could be correct, Your Honor, is that he completed a parenting class, and he did 6 sessions of a domestic violence program, and did not complete that. My argument on that really has to do with the fact that he stated in the record he couldn't afford it. DCF is responsible for providing services. That's part of their reasonable efforts obligation, and services under Rashida have to be accessible. A service is not accessible if somebody can't afford to do it. If the department had offered to pay for it, there may have been a different result.
Is it clear that he was terminated? I remember after 6 sessions or 10 sessions or something, they said he was terminated from the program. Is it clear that that's for inability to pay?
Well, Father said that he couldn't pay.
Judge find that?
I apologize, I don't remember.
But let me ask it a
think so.
different way. Are there any findings of fact that you say that the judge committed error in?
No. Your Honors, my other quick argument, and this is more important, I think, in the general scheme of care and protection matters, and this had to do with the question of the department's responsibility to provide visitation. As you see from the record, they were originally offered, I think, 2 hours a week. Child and parent were originally offered 2 hours a week. It was reduced to every 2 weeks, and then it was reduced to once a month. The department argues in its brief in response to my argument that this is an abuse of discretion issue, relying on a 30-year-old case, care and protection of Isaac and Jeremy. Those cases had to do with the department's ability to make discretionary decisions concerning placement of children, because they have to pay for these things, and it's within their discretion to do so. Under care and protection of Rashida, Your Honors, the Supreme Judicial Court clearly made care and protection of Walt, I misspoke. The Supreme Judicial Court clearly made a determination that the department's failure to provide visitation in order to maintain the relationship with the child is essential. And because the department in that case only offered every other week visitation, the single justice was well within their discretion to order, in this case, or in that case, 4 visits per week. Originally ordered, I think, daily visitation, then it was reduced to 4 visits a week. They didn't have a conversation about abuse of discretion or whether that was within the court's discretion, the department's discretion. They simply said it wasn't enough, and that was the judge's reasonable efforts view that it wasn't.
Walt said the standard was abuse of discretion. Walt, you're talking about care and protection of Walt?
Yes, Your Honor.
They said decisions related to normal incidents of custody generally are committed to the discretion of the department, reviewable only for abuse of discretion? Isn't that
normal instance of custody, yes. Under care and protection of, the only cases that have ever decided what that is were, I think, Isaac and Jeremy.
Okay, but you're not challenging the abuse of discretion standard?
Yes, I am. I think.
But based on Walt or some other authority?
Well, based on Walt, based on Rashida, yes. The opportunity to maintain a relationship with a child should not be based on the department's regulation. Their permanency policy provides for generally once a week visitation, and it would for 1 hour. That's what they do. A judge should have the ability to make a determination about what is necessary in order to maintain that bond.
Obviously this is an important question.
Yes.
And I guess I have 2 questions, but I'll just try to limit myself to the first one. Shouldn't some action, and we never see this, be taken when the visitation is reduced?
Yes.
Telling me 2 years later that the visitation was reduced wrongly is a very difficult thing for us to undo. But if, and I don't know if it's a reasonable efforts motion or some other kind of motion, were brought immediately, saying this should be 4 times a week, not 1, or this shouldn't be reduced from once a week to once every 2 weeks or whatever, would give a court an immediate moment to figure out, is that, because, and even if it's abuse of discretion, obviously there's some scope to that. If the discretion is, well, we thought 2 hours every 2 weeks is the same as 1 hour every 1 week, which to me it obviously isn't. Then a judge could say, like, those aren't the same. You can't give them 4 hours once a month and say it's the same as seeing the kid every week. So, you know what I mean? These things could be addressed and actually remedied.
And they should be. Under adoption of West, it's very clear that unless you raise it and tell the Department of Children and Families that they're not doing their job, you can't.
And I assume that you are appellate counsel only, right?
That's correct, Your Honor.
Now, I don't know what these people are appointed counsel at the beginning, right? So they do have lawyers. I'm sure those lawyers are beyond overburdened. I know how DCF and the lower court is beyond overburdened with these cases. But it would be helpful if someone, in some case, brought a motion like this so that guidance could be given sort of in real time.
Yes. I absolutely agree with you, Your Honor. My point in raising this issue is that if you were to publish a decision or even a rescript opinion, I do not think it would be helpful to this issue, to decide that issue in the decision. And so,
Is that within the rubric of reasonable efforts, or is it something else?
the issue of visitation?
Yes.
Oh,
Like, how are we supposed to reach, I mean, I understand if we were going to say, because of visits, 3 years ago, that's a good enough reason to undo everything. That's a tricky question.
No. I think when a case is before this court on a termination of parental rights issue, unless the issue was raised at trial, it would be inappropriate. And I'm not arguing that you should just jump into this and make that decision today. My biggest concern is simply to make sure that this issue is preserved for an appropriate time. And so that it isn't addressed either way.
It seems like a serious issue.
It's a very serious issue.
But again, the lawyers in the trial court, get someone to bring an immediate case. That would be so helpful.
I'll get right into it, onto it, Your Honor. If there are no other questions, I'll rest on my brief.
Thank you very much.
Thank you.
Very good argument. We will hear next from Attorney Gilchrist for DCF.
Good morning, Your Honors. May it please the Court, Claire Gilchrist for the Department of Children and Families. We are asking you to affirm the orders of the lower court today. The trial court correctly concluded, based on clear and convincing evidence, that father's violence and his inability to control his aggression rendered him unfit to parent the children and to meet their needs. These children lived in a home of violence. The oldest daughter and the son have PTSD. The oldest daughter had required medication to treat her nightmares. Both of those children, significant behavioral issues in school and in the community, and had behavior management plans, had to be placed in structured settings. So clearly the children are impacted. I do want to address briefly my brother's argument regarding the removal and what was going on at the time of the removal. The record here is that 2 children reported that that summer of 2021, before the September 2021 removal, that they witnessed that father punched mother in the face. So there was evidence of a very recent incident.
Not just a 51A that we can only consider for some limited.
And this is finding 71, finding of fact 71.
Is removal a live issue?
No, because it is subsumed in the trial on the merits, and there was a 72-hour hearing where father had the opportunity to rebut the evidence. As far as
So what do you think we should do here? Because the father he says that essentially the removal of the children was the original sin, and everything. I guess everything that follows is invalid because of that. So do we just address the merits on the finding of unfitness and the termination, or?
I mean, I think the record at trial includes, what happened at the beginning of the case, so the judge can look at all of that. But the evidence doesn't support father's version of events. So that's what I would say, is that the judge made findings, father doesn't contest them, and those findings do support that the children were had an immediate danger of abuse or neglect at the time of the removal. As far as reasonable efforts here, regarding visitation, as father concedes in his brief, he didn't file a motion for abuse of discretion in the lower court.
I thought reasonable efforts were raised.
I'm sorry?
I thought in his brief he says reasonable efforts were raised somehow in the lower court, no?
He did file a motion for lack of reasonable efforts. However, there was no follow-through with that.
Meaning the court didn't rule on it?
There is no indication from the record that there was a ruling from the court.
Did you respond to it?
My understanding is that at the time, Father, I think there was a change in attorneys, and then that was not pursued. So I'm not.
Well, it was raised prior to the trial, correct?
A motion for lack of reasonable efforts was filed prior to the trial.
So doesn't that put the burden on DCF at the time of trial to show whether you responded to the motion or not? Doesn't that shift the burden to you at the trial to show that, and maybe always, that reasonable efforts were made? And if the judge didn't discuss it, what happens then?
So the department, no matter what, has to show at trial, at a termination trial, that it's made reasonable efforts.
I thought the judge found reasonable efforts were made.
Yes, she did. And again, that's an uncontested
So it's properly
finding.
raised, it's just that the judge made a finding that their reasonable efforts were made.
Correct.
Yeah.
Yes, and the record supported that finding, and that the fact Father had 2 years where he just refused to acknowledge his deficiencies, particularly around domestic violence, and he didn't remedy those shortcomings by the time of trial.
Can I ask you a procedural question? And again, I'm not saying it's outside the record, but counsel raises an interesting issue regarding post-trial visitation. Judge makes a decision regarding visitation. After the trial happens, the lawyer that is appointed for Father, presumably he's indigent because he's appointed counsel, files the notice of appeal. At that point, counsel for Dad is done. Then there's a problem with visitation. What is a father or a mother supposed to do in that circumstance? They have no lawyer anymore because the notice of appeal is filed. What are they supposed to do?
Your Honor, just if I may clarify, are you asking a hypothetical about where a judge has declined to order post-termination visits? Because I don't believe I don't believe Father is challenging that in his appeal. He hasn't challenged a lack of visitation order following termination. He's simply raising the issue of, during the care and protection, feeling that the visitation was inadequate.
Can I ask this? It looks to me like there's a reason for the reduction of visits from every other week to every 4 weeks in the event with the middle child that involves some violence in the during the visit. I gather that's why that was reduced, or do we not know that?
No, I think there's some confusion there. The visits were reduced to once monthly a year or two later, in the last few months of trial, when Father showed up at the middle child's.
Oh, in his school. Okay. And then, is there any explanation for the reduction from once a week to once every 2 weeks? Or that's unexplained?
There is nothing in the record concerning why that clinical determination was made. Sometimes families prefer the biweekly for 2 hours, so it's a longer chunk of time.
Doesn't sound like that's the case here.
No, but again, Father didn't raise any objections at that time to that arrangement.
Are the children still where they were at the time of trial?
I don't have that information, Your Honor.
Okay.
If there are no further questions, I rest on my brief.
I see none. Thank you very much. Very good argument also. And we will hear now from Attorney Grantham O'Brien.
Good afternoon, Your Honors. Tamika O'Brien on behalf of the children. I do have an argument, but I thought I would address a couple of the Justice's questions. Justice D'Angelo, you had asked about the status of the trial attorney after a notice of appeal is filed. The trial attorney still remains, as far as the trial attorney still remains the trial attorney. So when an appeal gets assigned to an appellate attorney, the issues regarding visitation still remain with the trial attorney. Now, that can kind of, sure. Also, Justice Rubin, and you have to bear with me if I incorrectly interpreted your request about the visits being reduced. In finding of fact number 111 and 110, 111, father previously had biweekly visits, then they went down to weekly visits. It looks like in a period of time between September 15th, 2022 and August 29th, October 11th, 2023, he had missed a number of visits. So while it's not directly stated in the findings, could probably assume that that was one of the reasons. But to get to the heart of the children's arguments here, and yes, they're in the same places.
So that means the middle one is still not in a position to be placed any place but whatever the institution was where he was?
Yes. So unfortunately, with the summer holidays and school starting, I wasn't able to get out to see the children in the last couple of weeks like I would normally be able to do. But their position has not changed. The bottom line is...
When was the last time you talked to them?
Probably at the end of the school year, May.
May.
Yes. So these children in their short lives had lived in chronic chaos and violence. In the period of time between January 2020 and the removal of January 2021, there were 8 incidences of domestic violence. Many of these resulted in police responses. Father did not meet the children's educational needs. He would go to a meeting for testing, get irritated and frustrated and leave. And a lot of times in these kind of cases, we look at, well, this is how a parent treats a DCF worker, but not necessarily the child. But an ability to parent is, especially children with these kinds of needs, is going to require a parent to be able to work with providers and service providers. And in this situation, he showed no willingness to do this. He was in a defensive posture throughout this case from the very beginning. He may have done a service here or a service there, but he would say, well, I'm only doing this because DCF is requiring it of me. And he would defend, defer, and deflect. It was mother's fault. It was the children's fault. It was the child's fault because she, caused the removal. It was the child's fault because he was throwing toys during a visit. It's always someone else's fault. And in these situations where you've got these kind of children who require this level of special care and needs, we need parents who are able to manage those needs for those children, not just manage the children, but manage the whole system of needs for the children.
Can I ask a question?
Yes, sir.
The plan for the youngest child, I guess, if there is no contact, remains adoption by the current foster parent, is that correct?
Yes.
Or parents?
But mother's rights were not...
Yes, I was going to ask about that. I don't understand how this is supposed to work. How can you have a pre-adoptive home and years later there's still a parent without a terminated rights? How will the child gain stability?
Well, and I was actually speaking with my sister about this earlier. At some point, DCF would likely move to terminate mother's rights if she was not in a position to reunify with the children. And
but they think she still is.
I'm not entirely clear on whether or not they think she still is, but I know that with DCF, they keep the goal for the child as adoption so that they can continue to look for an adoptive resource for all of the children, no matter what.
Okay, but I want to start with the youngest one. I know your time has expired, but if you could answer the questions, that would be great.
Could you repeat the question?
The youngest child seems like they might be in a situation where they could be adopted, and you are arguing, yes, let's terminate affirm the termination of the father's rights so she can be adopted,
Correct.
which is what the judge found was in the best interest of the child.
Correct.
But she can't be adopted.
That's correct. She can't be adopted as long as mother's rights are intact. But
And this trial ended how long ago?
I believe about a year ago.
Okay, and yet nothing has been done to actually free the child up for this adoption.
As far as I am aware, nothing.
Well, you're the counsel for the child. I think
Correct.
you'd
But
be
as
aware.
far as I'm aware, DCF has not moved to terminate mother's rights. And DCF would be able to speak further on to that, but
Well, I'm not saying they should or shouldn't be terminated. I have no idea what the situation is, but I'm just trying to piece together, and that doesn't mean that the rights of the father shouldn't be terminated either. But what's going to happen to this child is my actual concern. I mean, people may grow tired of not being able to adopt a child, and it's years, right? How old is the child now, the youngest one?
the child is 5.
5, so whatever, over 20% of her life has been since the termination. She's been in this situation for years. That's not up to you, I guess, but it is a little funny to say it's adoption except DCF, and I should have asked, I guess, her. It didn't occur to me. The oldest child
Correct.
is described as having mild intellectual disability, but her IQ is described as 58.
I did notice that.
You've met with her, right? Or no?
So her position is that she doesn't want to be adopted. She would like to go back with mother. That's her position.
And having met with her, would you agree that it's a mild intellectual disability? Or you think it's what an IQ 58 would reflect, which would be something more profound?
Not having a background in any kind of special education or I'm not able to speak to that. My understanding from her is that she goes up and down. It depends. She's in a specialized setting for school. She has good days, bad days, but her position has remained. She would like to go with mother. She doesn't want to be adopted.
I'm trying to figure out the best interests of these kids. I understand the position. I think it's probably substituted judgment given their age, although I'm not sure about the oldest. But it's fine that that's their position. I'm just trying to figure out if they're actually being cared for properly.
I believe that they have been cared for as well as they can be cared for in the legal position that they are in. Mother's rights have not been terminated. They're in placements that are stable at this time. That can always disrupt, but it could disrupt at any time, no matter what. But it's not in their best interest that father's rights be...
I understand that argument. Of course I understand that argument. But I'm still concerned about
I mean, yes,
whether
and it's a valid concern. It is. I wish that I could tell you that, everything is okay now that father's not in the picture anymore. But the damage has been done to the extent that I'm not sure that any of these children are ever adoptable. Perhaps the youngest one, because maybe she was able to escape some of that level of violence and PTSD. I can't speak to that. I can speak to the fact that, these are children who have some really significant needs. And sometimes we come in here in cases and DCF says these children have significant needs and they have ADHD and dyslexia. These children don't have that. I don't know if they're ever going to be adopted. I don't. And it is my hope that somebody can help and adopt them. And I know that DCF was looking at a kinship placement in Connecticut, but there were some issues there with an ICPC and some criminal background. But right now, the middle child has not stepped down into a position where they can start looking for a family. So it's a tragic situation. It really is. My time has expired, and I could talk to you all day if you'd like, but I'm
and
sure
I could
you're
too,
hungry.
but we're not going to. All right. Well, thank you very much, and I appreciate, I mean, you are counsel for these children, and if you can advocate for them in that role beyond just arguing the appeal, I don't know if you're allowed to or what the rules are, but I hope someone is advocating for
I
them.
can say that their trial attorneys have been very active. You know, the level, when I first got on the case, I got an entire page of email about these children from each, and that was nice not to have to chase somebody down. So they are very involved. So, thank you, Your Honors.
All right, thank you. Very good argument from all of you. These are very difficult cases for us, so thank you. The case is submitted. That concludes our sitting for today, and therefore, with thanks to the court officers and court staff, we stand in recess.